On the record, wait, which part? Page? Yes, she's on Callahan. On the record, in the matters of the people of the state of Michigan versus Callahan, file number is. Do we have Ms. Donnelly? We do not. Okay, we'll call that back. When your attorney returns. You're on Callahan, and the other one is
Coleman.
Ms. Wanji's not here.
I've talked to both of them this morning, so I know they're present. I just not sure if they're present.
Okay, sounds good. Yeah, but we don't have.
And I can get the other prosecutors for other cases this morning. I believe they're out just in the hallway.
Thank you. You don't know if Mr. Etheridge is here? I haven't seen him.
I have not seen him.
Ms. Donnelly is here. What are you on?
Young.
Oh, he's in custody. Okay.
Yep.
Okay, on the record, in the matter of the people of the state of Michigan versus Callahan, file number 23-03029, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of defendant Callahan, who is present and standing to my right.
Okay, and Ms. Callahan, today's the date and time that was set for a preliminary examination. Are we proceeding or are we requesting an adjournment?
Your Honor, yes, it's my understanding that the prosecution has one officer here. We were stipulating to an adjournment. Ms. Callahan would waive her 21 days so that we can also have another a CPS investigator here as well.
Okay, and so Ms. Callahan, you understand that you have the right to have a preliminary examination within 21 days of the date that you're arraigned. And due to the fact that the CPS investigator is not present, are you willing to waive the timeline so this matter can be reset so that additional parties can be subpoenaed to court?
Yes.
Anybody threatening you to get you to waive the timeline?
No.
Any promises being made to you to waive your timeline?
No.
Oh, we'll get you a new date. January 11th at 9:30. Any additional matters for today's record?
Nothing for the people.
Nothing for defense. Thank you.
You're all set, ma'am. We'll get you your notice to appear. Okay.
And Ms. Wanji's present, so we can handle it. Coleman.
Very good. Do we know if Mr. Etheridge is in the building or if someone's covering for him?
He's here.
I have not seen him. Okay. On the record, in the matter of the people of the state of Michigan versus Isa Williams. I'm sorry, this is Ms. Wanji's. Jerron Summers, file number 23-02864. Council appearance.
Jeff Rodos on behalf of the people, Your Honor.
Morning, Your Honor. My name is Wanji, attorney for Mr. Summers.
Okay, today was the date and time that was set for preliminary examination from carrying a concealed and police officer assault. Are we proceeding today?
No, I would like to request a lineup. I do believe that a lineup in this case is of essence because it's my belief that the actions of the police officer were based on the description that was supposed to be based on the description given by the 911 tape. When I received the 911 tape, I do believe that after that, the next step is for us to ask for a lineup.
Okay, and so you would need an adjournment for that purpose, correct? Okay, looks like he was arraigned back in September, so we've already addressed timeline. Let's see.
We have, Your Honor.
we'll reset this. I would imagine, well, we'll go to our next available date in January. January 11th at 9:30. Thank you. Any additional matters for today's record?
Nothing from the people, Your Honor.
Nothing, Your Honor.
Thank you. You're all set. Mr. Doby, which matter are you here on?
I'm here on Jalen Jackson Wade, which is going to be a waiver, I believe.
Okay, on the record in the matter of the people of the state of Michigan versus Jalen Jackson Wade, file number is 23-03297, council appearance.
Good morning, Your Honor. Michael Doby for the people.
Your Honor, Fred Blackman on behalf of the defendant, standing to my right opponent.
And Mr. Jalen Jackson Wade? Okay, today's the date that was set for preliminary examination, and the parties wish to unconditionally waive the examination.
That's correct.
Yes, Your Honor.
Okay, was there an offer extended?
There has not been.
Okay. Mr. Jackson Wade, do you understand the purpose of the preliminary examination? Okay, so you have the right to require the prosecutor, which is the Office of the Attorney General, to put forth evidence to establish whether or not they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that? You wish to unconditionally waive your right to an examination today? Unconditional waiver meaning no one is promising you anything or threatening you to make you do that waiver, correct? And you understand that once you waive this matter, you can't change your mind. This matter will be bound over to the circuit court without a hearing on probable cause at the district court level. And you're waiving freely and voluntarily? Thank you. And find your waiver to be freely and voluntarily made. Your matter will be bound over to the circuit court. Bind over date is going to be December 20th. That's the date they'll get the file from the district court. That's not a date that you need to appear in circuit court, okay? Your next court date will be in circuit court. It'll be a pretrial. Mr. Blackman will be made aware of that date. Remain in contact with him, okay? Has your address changed since your arraignment? Okay, if it does change or your number changes, your responsibility to update the court with the valid address so that you can get your correct notices so that you won't end up with a bench warrant for failure to appear. Bond was set at 2,000 personal recognizance. That will continue. Any additional matters for the record, counsel?
No, thank you, Your Honor.
Thank you. You're all set.
Thank you.
Thank you.
Remind me of your other matter again.
Coleman,
On the record in the matter of the people of the state of Michigan versus Dustin Coleman. File number is 23-03542, council appearance.
Prosecutor Paige Petrowski, on behalf of the people.
Good morning, Your Honor. Melanie, everyone. The public defender of this one, Mr. Coleman.
How are you, Mr. Coleman?
All right,
Today was the date and the time that was set for a preliminary examination on assault with intent to do great bodily harm, less than murder or by strangulation in a domestic violence second offense. Are we continuing to exam today?
We still need some discovery. We would like to have the 911 tape. Because we don't have a question and we don't have any yet. So we're asking for my client to wait for 21 days. I have discussed with him and told him that we're not waiving the preliminary exam, which is within the timeline. And he agrees with that.
That's correct, sir?
yes,
Okay, anybody threatening you to get you to waive the 21-day timeline?
no,
Any promises being made to you?
no,
Okay, we'll reset this.
February 1st and
February 1st at 9 a.m. You have any questions today, sir?
no, Your Honor.
Okay, there was bond at 10,000 personal recognizance with a no contact order in place for the protection of a Melissa Coleman that will continue, as well as all other bond conditions. Any additional matters for the record?
nothing for the people.
No, Your Honor, thank you.
You're all set. Thank you.
Thank you.
On the record, here with Lewis. On the record in the matter of the people of the state of Michigan versus Gregory Michael Lewis, file number is 23-02745. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Stephen H. Freeman, public defender on behalf of Mr. Lewis.
Okay, Mr. Lewis is present via Zoom. Mr. Lewis, can you hear us? You're muted.
Yes, I can.
Very good. Today was the date and the time that was set for an additional probable cause conference. The defendant was still undergoing a screening for the specialty court at the 30th Circuit. Is that screening still being done or was it completed?
As of this time, Your Honor, I believe that screening is still underway. I know I had some conversations with Mr. Freeman about that earlier this morning, and so I would leave it to him on how he wants to proceed.
Mr. Freeman.
Thank you for asking, Your Honor. It would be our intent to unconditionally waive preliminary examination and continue with the mental health court and circuit court. Thank you.
Mr. Lewis, is that correct?
Yes, it is, Your Honor.
Okay, so you have the right to have a preliminary examination in the district court. You recognize that?
Yes, I do, Your Honor.
You have the right at your preliminary examination to require the prosecutor to meet their burden of establishing whether or not they have sufficient probable cause that a crime was committed and probable cause to charge you with the crimes. You understand that, Mr. Brodowitz?
Yes, yes, I do, Your Honor.
Anybody threatening you in order to get you to waive your preliminary examination?
No,
Any promises being made to you if you waive the exam?
no, there's not.
You're waiving it freely and voluntarily?
Yes, I am.
Lewis, there's a form that needs to be signed. May I have your permission to sign for you?
Yes, you do.
Thank you. And vote.
Yes, please.
Oh, okay. Oh, I didn't know that.
Yes. Okay, I find your waiver to be freely and voluntarily made. The matter will be bound over to the circuit court for a bind over date of December 20th. That's the date they get the file from the district court, not a date that you need to appear in court, okay?
Okay,
Your next court date is going to be a pre-trial in the district court. Your attorney will be made aware of that. You remain in contact with him. Has your address changed since your arraignment?
no, I haven't.
Bond was set at 1,000 personal recognizance, and that will continue. I also have here people of the city of Lansing versus Gregory Michael Lewis, file number 22L2711251. Mr. Lewis, you're in warrant status on this matter. Do you know why?
I don't know what you talking about.
Okay, this is a citation that you received for a registration expired plate, and you owed $180. You told.
I made a payment, last month. I was supposed to make a $50 payment last month. I did so. And then, $50 a month until the $180 is paid off every month. What I was told.
And who's interacting the payment? The warrant was entered after the payment?
The warrant was supposed to be listed.
I see here November 21st, it says defendant to pay $50 on the 27th of each month, starting November 27th. Let's see, I see, that's why. It looks like you came in and made a payment.
I think I was a day or two late. I do apologize.
Yep, you were late with the payment. That's the issue, but you were only 2 days late. I think wasn't the 27th the holiday? Did I make that up?
I think, yeah, it was 2 days late. I really apologize.
Okay. Oh, don't forget to make your payment on the 20th. Are we open the 27th? The 27th of this month we are. I'll quash the warrant. I just
Okay,
need the
thank
file
you.
to quash that warrant. Okay, and your bond and the other matter will continue. Do you have any questions?
No, Your Honor.
Any additional matters for the record, counsel?
I would just put on the record that as he's being screened, the mental health court offer does remain open up in circuit court, Your Honor.
Sounds good.
I concur, Your Honor. Nothing else from the defense. Thank you.
Thank you. You're all set.
Thank you.
You're welcome. Mr. Michelson here for a man. Where's he logging in? I was in the building. Oh, he's in the building. Yeah. Okay. Let's see. Is Elaine Edwards present?
Yes, Your Honor, she's outside.
Are we running an exam?
I don't believe so, Your Honor. I don't believe the people's witness has appeared.
On the record, in the matter of the people of the state of Michigan versus Elaine Michelle Edwards, file number is 23-03508. Counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Elaine Edwards, who is present and standing to my right.
Ms. Edwards. Say was the date that was set for a preliminary examination on an assault with a deadly weapon. My understanding is that the necessary witnesses have failed to appear. Is that accurate, Mr. Brodowitz?
Yes, it is, Your Honor. I've called the hallway in the courtroom multiple times. The complaining witness has not made their presence known to me, so the people are unable to proceed at this time.
Ms. Donnelly.
Yeah, then Your Honor would be asking that this be dismissed without prejudice.
Motion to dismiss without prejudice is granted. That means the case is dismissed today. You would need to give us about 72 hours to remove anything from lien that was restricted as part of your bond. However, these people do have the right to reissue this charge against you. If they do reconnect with the necessary witness, that means a new warrant will be issued and you'll have to be rearranged. Do you understand that?
Yes.
Do you have any questions?
No, ma'am.
Any additional matters for the record?
Nothing from the people, Your Honor.
Not for defense.
We'll get you a copy of the dismissal in just a moment, okay?
Yes, ma'am.
Real quick before you call this case, is there a Brianna Jackson here?
Sounds good. Do we know which courtroom Mr. Etheridge is in?
Not sure, I can check, to be honest. I have
What
I only have Asa Williams left.
about Robinson? Is she here too?
Yeah, she's here too.
You have Asa Williams.
Is he supposed to be? I don't think he's downstairs.
Williams?
Williams, I don't think he's downstairs. Is he downstairs?
He's not on our jail list, I don't think.
Yeah, I don't know
He
why
failed to appear.
Eaton didn't take him. Yeah, I can't get a contact him now.
Oh, wait, it does say in jail. He's not?
Remember, you gave him a 10% last week. I thought he was gonna be taken by Eaton because he's got a warrant out of
It
there.
says that.
It's,
Then
I
it
can't
hold-
find him in Eaton.
Then it has hold, felony hold.
Yeah. I don't, it is a non-public case down there. I don't know if that, but I can't find him even on the jail website. Yeah, go ahead and call him. I'm gonna look for.
Counsel, which matter are you here for?
Alexander Priest, Your Honor.
On the record in the matter of the people of the state of Michigan versus Alexander Kemp Priest. File number is 23-03532.
Jeff Roberts on behalf of the people, Your Honor.
Jennifer Cagliese on behalf of Mr. Priest, case 6162.
I'm sorry, Miss Reese and Mr. Priest. How are you both?
Good, thank you.
Right. That's it. Okay, today was the date and the time that was set for preliminary examination. I did have a note that we were going to treat this as another probable cause conference.
That is correct. Last time we were here, Your Honor, we had not yet received our substitution or our appearance that we had just been retained. I hope that the court has now received those. We did receive discovery.
Yes, I did receive and I signed the substitution yesterday. And then there is a TA 53 bond violation.
That is correct. My client does wish to waive his 21 days and set the preliminary examination with witnesses for a future date, and he will plead guilty to the PA 53 no contact violation with an explanation.
Okay. We understand, Mr. Priest, that you have the right to have a preliminary examination in the felony matter within 21 days of your arraignment. Okay, and because of the transfer from one attorney to another, there was a bit of a backlog or time lag there. Are you willing to waive the timeline so that we can reset this? Anybody threatening you to get you to do that? Okay, any promises being made to you? Someone made a promise? Who made a promise? Okay. February 1st. Does February 1st work for you at
Yes,
9:30?
thank you very much. 9:30?
9:30. Okay, and then as to the PA 53 violation, you were arraigned on it and you were advised of your right to have a hearing on that violation. The allegation was that you had, or you violated the no contact order. You want to waive your hearing and enter a guilty plea to that? And you understand that at a contempt of court? Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Thank you. Okay, anybody threatening you to get you to waive your hearing as to the violation? Any promises being made to you if you waive the hearing for the violation? You want to enter a guilty plea? You're entering that plea freely and voluntarily? Okay, as to the violation that you violated the no contact order of your bond on or about November 22nd at 4 p.m. How do you plead? A factual basis, please.
Yes, thank you. Mr. Priest, did you send a third party to the residence of the victim in this matter?
Yes, ma'am.
And what was the purpose of that?
To retrieve my 16-year-old ill cat.
Did you believe that anyone was home at the time?
No, ma'am.
Did you have an attorney at the time?
No, ma'am.
Was there a court-appointed
I
attorney?
have a court-appointed public attorney that I could not get a hold of.
So you had not spoken to an attorney yet?
And,
Have you since spoken to Mr. Lisi? Has he explained the no contact in detail?
in detail.
You understand you cannot send third parties over to this residence or have any contact with the victim in this case,
Yes.
yourself or anybody else.
Yes.
Thank you.
Any additional matters or questions from the prosecutor?
Nothing from the people, Your Honor.
Okay, the court satisfied with the factual basis. I'll accept your plea to the bond violation, find your plea to be made freely, voluntarily, and intelligently. Your bond is going to continue. There is a no contact order protecting a DeShonda Stevenson, and you're not to be within 2,000 feet of wherever DeShonda Stevenson is. You're not to have contact directly or indirectly, including third-party contact with DeShonda Stevenson. Do you have any questions about that? Any additional matters for the record?
Thank you very much.
Nothing from the people, Your Honor.
You're all set. Thank you.
Thank you. Have a good day.
You too. Can we have your P number, please?
Yes, P66162.
Thank you. No problem. On the record in the matter of the people of the state of Michigan versus Demond Bisby, file number 23-00863. Council, can I have your appearance?
Jeff Rodowitz on behalf of the people.
Good morning, Your Honor. Attorney Derek Espinosa, public defender on behalf of Mr. Bisby. Mr. Bisby is in the courtroom standing to my right.
How are you, Mr. Bisby?
I'm well. How about yourself?
I'm doing well, thank you. It was the date set for sentencing. I have a pre-sentence report and recommendation. It was prepared on December 4th, 2023. Did you get a copy of that?
Yes, Your Honor, I did receive a copy of the pre-sentence investigation. I did have the opportunity to review it with Mr. Bisby. Also provided him a copy of it for his own review.
Mr. Flan, where are you going?
I was checking if I could use the bathroom. You're taking one.
Okay, Mr. Ferguson, do you need to speak to him?
I do not, Your Honor.
Okay. He needs to use the restroom. If they come, can you hold it for a couple of minutes?
Sure I can, but I already asked. If he comes, I'm definitely gonna go, if that's all right with you.
Okay, off the record, I'm gonna take his now, so that if they come, he can.
Fine, have you, we'll be with you. Thank you.
On the record in the matter of the people of the state of Michigan versus Isaac Flan, file number 23-03158, council appearance.
Jeff Rodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson to print on behalf of Isaac Fernandez by way of video conference from the Eagan County Jail this morning.
Okay, Mr. Flan, today was the date that was set for a hearing on a competency. I did receive a report. It was dated for November 29th. I think it was sent to Judge Buchanan. It made its way over to me. And the parties did get a copy of this report.
Yes, Your Honor.
Yes, Your Honor.
Okay, the body of the report and the conclusion is that at this time, the defendant is not competent to stand trial, but it's the examiner's opinion that he could have a substantial likelihood of attaining competency within the allotted statutory time of 15 months. Any objection to the body or the conclusion of the report?
Nothing from the people, Your
On
Honor.
behalf of Mr. Flan, Your Honor.
Okay, so the court will adopt the report, or incorporate the report as part of the court record. Will enter an order finding him incompetent and ordering him to undergo treatment to see if he can restore competency. Any additional matters for today's record?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor. Thank you.
Thank you. You're all set, Mr. Flan.
I'll be back shortly.
Thank you. Yes, sir. Okay, back on the record in the matter of the people of the state of Michigan versus Bisby. As to the pre-sentence report and investigation, do we need to make any corrections, updates, or deletions?
There was one correction that he wanted me to make on page 2 regarding employment data. And I guess it may be in other places in the report, but he does want to advise the court that he recently became employed at the Lansing Central working in the kitchen there.
The
Kitchen there.
what's the name of the place?
The Lansing Center.
Oh. When did you start there?
So the week before Thanksgiving.
Okay, very good. Any other corrections, updates, or deletions?
I don't believe so, Your Honor. Thank you.
Okay, you can address the court.
Thank you, Your Honor. Your Honor, I had the opportunity to go over the pre-sentence report recommendation with Mr. Bisby. He would ask the court to adopt the recommendation. He would ask the court to consider a lesser term of probation. I did advise him that he's likely to be able to get off of probation early if he is compliant, but he still would ask the court to consider a lesser term. Your Honor, he's taking responsibility for his actions. I think some of his behavior, although not an excuse but an explanation, is he does suffer from some mental health issues. He self-reports being bipolar, and I think there were some other issues. Throughout my representation of him, we did consider a couple specialty courts, but ultimately it was decided not to go that route, and he ended up working out a resolution that he has with the court now. He would ask the court to follow the Killebrew agreement with no upfront jail, and he would leave the other conditions up to the discretion of the court. Thank you, Your Honor.
Does your client want to make a statement for himself? Review your prior criminal history and then the pre-sentence report and the recommendation, as well as the attachments to the recommendation. State that you met the criteria for a moderate alcohol use disorder in early remission, moderate cannabis use disorder, and you met 4 out of 11 diagnostics criteria for substances. So the recommendation was for you to undergo some outpatient treatment. What was most concerning for me was the fact that you being a young man, I don't see any prior criminal action up until looks like last year. Then things somehow got bad for you. You've been having a considerable amount of interaction with the criminal justice system since that time. And so that was the concern, because something took place or something triggered that caused this demise. It does note here that you, at the time, were living at the Mission. Is that still accurate? Okay, that you were unemployed, but that's no longer accurate. You are employed now. And that you lacked family support. But it looks like you're getting or you're making some efforts to align your life so that things can be more manageable. Is that correct? Okay. And then have you been clinically diagnosed with any of the things that your attorney said that you were diagnosed with, or is?
Yes, bipolar schizophrenic.
Okay, or do you get treatment for that?
Yes.
Where and how often?
Jolly Road,
Oh,
CMH.
how often?
It should be every month I get a shot. I didn't get my shot last month because I had work and stuff like that, but I'm working on getting that updated. But it should be every month. Well, it's really weekly, but now I got a job, I got a balance to see the dates and stuff like that.
You definitely have to not just balance, but prioritize your treatment, okay? Okay?
Yes, ma'am.
Okay, because if you don't, then all the work that you're doing to try to piece your life back together could crumble because you're missing something. You don't want to be missing. So I know your schedule's gonna be different because you're working and you may have some reporting requirements, but that doesn't mean that you don't do your treatment. It also means the court's gonna order that you do the treatment. So if you don't do it, it's gonna be a violation of your probation, okay? Okay, the recommendation was to put you on a term of probation. And they recommended 18 months. I'm not going to start you out with 18 months probation. That's pretty long. I will, and you're not currently on probation, that's correct?
No, ma'am.
The order is for 12 months probation. While on probation, you are to maintain employment and provide evidence of that to your probation officer, okay?
That's what.
You're gonna continue your treatment at CMH and follow all recommendations, okay?
Yes, sir.
You're gonna attend a victim impact panel within 90 days, and you need to provide verification of that. You're gonna be required to submit to random preliminary breath testing and drug testing, and you are responsible for the cost of that, okay?
Yes, sir.
You're not to be at any bars or nightclubs. You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use or possess alcohol, marijuana, or controlled substance unless you have a valid prescription. If you have a valid medical marijuana card, you need to show a copy of that to your probation officer immediately, okay?
Yes, sir.
Okay, do you have any questions about your probation status so far? Okay, I'm gonna order that you submit to outpatient substance abuse treatment. There is a $30 per month oversight fee for probation that you'll be responsible for. There's a $90 assessment fee that you're responsible for. There's a statutory prosecutor cost recovery of $120. $75 crime victim rights per statute will be assessed, and also per statute a $50 state minimum cost. I'm gonna waive any discretionary fines and costs because your hands will be full with that. $695, and you'll be able to make payments on the $695, okay?
Yes, sir.
Do you have any questions about your fines and costs?
No, ma'am.
Lastly, I have an advice of rights here as to Probation, it says you have been sentenced to a term of probation at the 54A District Court. The probation conditions have been individually tailored and are specific to address your assessed risks and needs. Except for domestic violence, criminal sex crimes, stalking offenses, or an offense where the defense of guilty but mentally ill was asserted, you may be eligible for early discharge from probation. You have the following rights. You have the right to request early discharge from probation once you've completed half the original term ordered by the court. Your probation officer may, but is not required to, request early discharge on your behalf. Your probation officer would send a copy of the request to the prosecuting attorney, and the prosecuting attorney would have 14 days from receipt of that request to file any written objections to your early discharge. You can make your own request for early discharge by using the court's MC 512 form. You would serve a copy of that form on the probation department and then also on the prosecutor's office. Prosecutor's office has 14 days from receipt of that notice to file any objections in writing to your request. If a hearing is scheduled to address your request for early discharge, you do have the right to hire an attorney to represent you for that hearing. You do not have the right to court-appointed counsel for that hearing. Do you have any questions about those rights?
No, ma'am.
Any additional matters for the record today?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
Thank you. When you leave here, just check in on the 5th floor with the probation department to make sure they have accurate contact information for you, okay?
Yes, ma'am.
Thank you, Your Honor.
Thank you. You're
Have a
welcome.
nice day.
You too. On the record in the matter of the people of the state of Michigan versus Ali Gayette, file number 23-02911, council appearance.
Morning, Your Honor, Assistant Prosecuting Attorney Melanie Smith on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Gilyard.
Okay, and today was the date set for sentencing. I do have a pre-sentence report. It was prepared on December 1st. Council, did you get a copy of these?
I did, Your Honor, thank you.
Yes, Your Honor.
Do we need to make corrections, updates, or deletion?
Nothing from the people.
Your Honor, at this time, Mr. Geedy reports that he is actually going to be starting work next week at a temp agency, earning $16.50 an hour, working approximately 40 hours per week. At this time, that is the only change that I have.
It's gonna be starting work where?
I'm sorry, Judge?
Where is it gonna be starting work?
At a temp agency.
Okay. Okay, any other corrections or updates?
Not at this time.
Do we have any impact statements or anything today?
Nothing from the victims, Your Honor.
Okay, you can make allocution.
Yes, Your Honor. Mr. Geedy, at this time, we'd ask that the court would follow the recommendation at this time located in the pre-sentence investigation interview, although there was a Killebrew agreement to 24 months of probation per the plea agreement. We'd ask that the court follow that Killebrew agreement. I don't believe that there's anything here in the pre-sentence investigation report that shows that he would not be a good candidate for probation. In fact, he's been compliant with the CPS investigation that has been ongoing at this time. And he's currently completing parenting classes, doing well with those, abiding by all the requirements that they seek of him. So we'd ask the court to follow the Killebrew agreement with the 24 months of probation.
Your client wish to make a statement?
Your Honor, I really am really sorry what's going on, especially me wanting to be a father to my children and having impact in my community. I only ask Judge, please, if it's possible, can you remove the ban from me going back home, please? I'm missing my son's important milestone. Example, I never left his side. He's learning, he's walking now, and I'm not there to see it. Frankie is he's going back to school, but you know, he needs that solidity at home where mom and dad is there. Because obviously, when dad is not home, he wants to do whatever he wants to do at school, and then I have to be there to make sure that things go right. And I'm learning a lot, taking courses from my parenting class as well, and I really need to go back home to my children.
Thank you. Did you want to add anything, Council?
Briefly, Your Honor, we do also ask that you follow the Killebrew. We believe that it was constructed based on the individual needs of this defendant. I'm very pleased to hear that he not only accepted full responsibility for his actions in the public pre-sentence investigation report, but also that he is learning the things that he needs to from the classes that he's taking. I do believe that modification of the no contact order would be just a bit premature at this point. My recommendation to the court would be that once the parenting class is completed and verification of that can be given to the probation officer, that then the no contact order be modified at that point to allow Mr. Gilyard back into the children's home. Thank you.
Thank you. Mr. Gilyard, I echo the sentiment of the prosecutor that I think it's good to hear that you are learning a lot in your programming as it relates to parenting and childcare. And I agree with you that your children need a father to be there, but they need a father that's not going to harm them to be there. And that's the concern. A year before the court on a matter indicating that you struggle with your ability to parent without putting your children at risk. And so there's a program in place right now to help give you the tools you need so that you can better parent and better be supportive of your family, being a better example for them and a better member of this community. And so we don't want to take actions too quickly that would prevent your ability to garner those tools before you go back into the home and before you're back unsupervised with your child. My understanding is there's already a parenting program in place.
Yes, ma'am.
Okay. Okay, and so we're going to follow the parenting program. I think the recommendation that the prosecutor has provided with providing the probation department with an update when appropriate for us to address the no contact order, that the court will adopt that, and that's what we'll do. At this point, your sentence will be 365 days Ingham County Jail, credit for 22 days. Will suspend the remaining balance upon completion of 24 months of probation. While on probation, the no contact order and protective orders will continue. You're not to engage in any assaultive or threatening behavior. Do you understand that? You're not to purchase or possess firearm, ammunition, or weapons of any kind. Do you understand that? You're not to use, purchase, or possess alcohol, marijuana, or drugs unless you have a valid prescription. You will be required to submit to random preliminary breath testing and your analysis testing, and you are responsible for the cost of that, okay?
Yes, ma'am.
Is there a problem?
No, no.
Oh, okay. You're not to be at any bars or nightclubs while on probation. You have obtained employment, you're required to maintain employment and provide verification of that. I'm going to order again that you follow the parenting program. And follow all child protective service orders.
Yep.
Do you have any questions at this time?
No, ma'am.
As to fines and costs, there's $75 crime victim rights fee that you're responsible for. $50 state minimum cost that you're also responsible for. Probation oversight fee is $30 per month. So for 2 years of probation plus the statutory fines and costs is $845. I'm gonna waive discretionary fines and costs because your hands will be full without that. And you'll be making monthly payments on that, okay? Lastly, there's an advice of rights as to probation. It says you have been sentenced to a term of probation in the 54A District Court, except for domestic violence, criminal sex crimes, stalking offenses, or offense where the defense of guilty but mentally ill were asserted, you may be eligible for early discharge. It also indicates that your probation conditions have been individually tailored and are specific to address your assessed risks and needs. But you do have the following rights. You have the right to request early discharge from probation once you complete half the original term ordered by the judge. Do you understand that? Your probation officer may, but is not required to, request early discharge on your behalf once you become eligible. They would send a copy of that request to the prosecuting attorney. The prosecuting attorney has 14 days from that request to. Do you have a concern about what's going on over here?
No.
Oh, okay, thank you. They have 14 days from the date of that request to file any written objections. You can make your own request for early discharge from probation once you become eligible. You become eligible once you complete half of the term that's ordered by the court, and then you not have violated within the 3 months prior to that request. Do you understand that? You can get the court's MC 512 form off the court website, or you can request it from your probation officer. You would send a copy of that completed form to your probation officer, and then you would serve a copy on the prosecuting attorney. The prosecuting attorney has 14 days to file any written objections. Do you have any questions about those rights? If a hearing is scheduled to address your request for early discharge, you can hire an attorney. You have the right to be represented by one at that hearing, but you do not have the right to a public defender for that hearing, okay? Any questions? Any additional matters for the record, counsel?
Nothing from the people. Thank you, Judge.
No, Your Honor, thank you.
Thank you. Good luck to you, sir. On the record in the matter of the people of the state of Michigan versus Kyla Latrice Marshall, file number 23-03490, counsel appearance.
Jeff Rodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Daniel, on behalf of this Marshall, who's presently standing to my right.
We need a substitution.
Substitution.
Yeah, we got an appearance, but we need a substitution of counsel because Robinson had already appeared on this. So we need to get that in the system. I do see your appearance though. Okay.
Your Honor,
Yes.
the issue with this case today, I was gonna be motioning to withdraw.
You're making a motion to withdraw?
Yes.
Well, you're not technically on it yet. Because you didn't sub in. And why are you making a motion to withdraw?
Due to a conflict of interest, I'm here to represent the victim.
You represented the victim in this matter. You said it. Ma'am, you had something you wanted to say?
I do.
Yes, ma'am. I'm going to first advise you while you gather your breath. You do have the right to remain silent. So anything you say can be used against you, okay? Is that a yes?
Yes.
Okay. And
Yeah.
you still want to say something?
I do.
What is that?
So I'm not too sure of what's going on because this lawyer was obtained by Darius Moore, the plaintiff. I was contacted by this lawyer and the lawyer said, I am your lawyer. I was obtained by Darius Moore to represent you. He's not going to court. He's called and left a message at the prosecution. He's not going to court. I have also had over 75 calls from Darius Moore, as well as text messages in regards to things he purchased to get me, reel me back in, to speak with him, this, that, or the other. And then after that, Darius Moy's child's mother reached out to me and asked me what happened. And I told her what happened. Darius Moy then contacted my mom and made a threat to my mom saying, I'm going to court because she's talking to my child's mother. I guess because of me letting her know everything that's been going on.
Okay, let me back up a little bit. Which lawyer contacted you and
This
said?
lawyer standing next to him.
Mr. Doyle contacted you and told you that he represented the protected party in this matter?
He contacted me. He said, I'm your lawyer. I'm going to represent you in this case. He said I was obtained by Darius Moore.
You were obtained by?
He was obtained by Darius Moore for me.
Mr. Doyle?
Your Honor, that's not accurate. I did contact her and asked her whether or not she was looking for representation if she wanted me to represent.
You had a public defender in this matter, correct?
I did in the
Yes.
beginning.
Okay, and so Mr. Doyle, you were not appointed on this case, correct?
Right.
Okay, and so, but you were retained
Yes, Your Honor.
by this man, this lady?
By relatives, somebody that's indicated she was looking for a lawyer. Your Honor.
Someone indicated? One of her relatives?
I believe it was.
Which relative?
I don't have the actual name and contact information.
They
but
paid
wanted
you?
me to- I know, Your Honor, I wasn't paid. This was gonna be a pro bono case for her. So I remember, once I find out the victim is Darius Moy, it's a conflict of interest, so I'm.
Okay, so did you have a private protected communication with her before that happened?
Oh, yeah.
Have you ever met with her outside that phone call?
No, yeah.
Oh, so you just reached out to her and asked her if she needed an attorney and that someone had reached out for you on her behalf?
That's correct.
Okay, but they had not paid you?
No.
Do you know who the person was, ma'am?
Darius Moore. I have the text message to prove it. And this man also let me know that Darius Moore obtained a lawyer.
You have a text message from whom?
From Darius Moore.
Okay. Okay, but you didn't receive a text message from this attorney. You received a text message from the protected party?
The only text message that I have from this man is that he asked me to send him my email so he could send me the discovery, and that was about it. So most of our conversation was via the phone, over the phone.
Sounds like a mess. Mr. Joy, I'm interested in knowing who contacted you.
And I'll have to go back to find the exact phone record. They
Okay.
indicated.
Well, I'm gonna have you bring those to me. Because this may have been grossly compromised. I have a responsibility to figure out if that was the case.
Yes, Your
And so you were scheduled, ma'am, to have a preliminary examination in this matter today, but due to the information that you brought before the court, I'm gonna find good cause to adjourn the timeline so that I can reset this. Mr. Doyle did file an appearance and it sounds like he must have gotten some discovery, but we didn't get a substitution. So technically, Ms. Robinson is still on this match.
The substitution was signed and sent over to Mr. Doyle's office on November 20th.
I recognize it, but we didn't get it. So until I sign it, there's no such substitution. Yes, ma'am.
I would, because of his criminal record, I would also, I don't know if I can do this here, but I'd also like to ask for a PPO.
Okay, well, no, you don't do that here, you do that over at the circuit court, okay? You can go file a request for a PPO. And then technically, Ms. Robinson is still your attorney until she is substituted out. And so you should follow up with her about questions and concerns as it relates to that, okay? Okay, and then you can share with her any other information that you should not put on the record as it relates to your concerns about communications that you may or may not have had with this attorney, okay?
Yes, ma'am.
Okay, and then Mr. Doyle will bring us information about who contacted him, how he received contact to represent you, and any information that supports how he was paid, if he was paid. And then we'll address that at the next court proceeding. I'm gonna set it for another probable cause conference.
And 9.
December 28th at 9 a.m. This here?
Yes.
Darius Moy, is his name?
Yes, sir.
Is he in the courtroom?
Yes, he is here.
Who's there this morning? Mr. Moore, can you stand up, please? Here you go. Thank you. Did you hire Mr. Doyle? Excuse me?
No.
Have you ever met Mr. Doyle? Has he represented you? He represented you in the past? Okay. When's the last time you had contact with him? A few weeks ago? About this case? Oh, okay, about something else? Okay, you called him? Okay. And so your representation is that you've never contacted Mr. Doyle about this young lady? Okay, thank you. I'll wait for the records that you provide to the court, okay?
Yes, Your Honor.
Any additional matters for the record today?
Nothing from the people, Your Honor.
Thank you. You're all set for today. We'll get you your notice. Did I do both Ms. Wangy? No. Ms. Wangy, is Ralph Mcfaden present? Oh, he is. He's back there. Are we having an exam on that today? We are, okay. Mr. Mills?
Yes.
Sorry? Okay. On the record in the matter of the people of the state of Michigan versus Jeremiah Marcos, file number 23-02623. Council appearance.
Jeff Reynolds on behalf of the people, Your Honor.
Good morning, Your Honor. Stephen Milks on behalf of Mr. Marcos, who is present standing to my right at this time.
Okay, let's see. Today was the date that we set this matter for a review, because he was being assessed for mental health court. My understanding is that he was clinically eligible, but that was all we had last time.
Yes, Your Honor. At this time, Your Honor, I've been in contact with Ms. Bessenden over 55th District Court, Mental Health Court. We've got the paperwork filled out at this point. And so we're waiting on whether or not he's going to be accepted into the program.
Okay, so they're still reviewing paperwork there. Okay.
I think last time we were here, there was some confusion regarding where the paperwork had to go to on my end, because it's the defense who usually does the transfer, and so that was on me, and so we got the paperwork going, and we're just waiting for all that to formally be accepted, Your Honor.
Okay, sounds good. So we will set this out to allow them to review and hopefully complete that paperwork. Another review date, please. I'm sorry. We would hope that would be done in January. Let's shoot
Yes.
for that.
Okay. We can do January 5th at 9.
January 5th at 9. Do you have any questions today, Mr. Marcos?
No, ma'am.
Okay, and so your bond will continue, and then hopefully by January 5th, the paperwork will be completed. But I'm sure Mr. Milks will stay on them. Any additional matters for the record today?
Nothing from the people, Your Honor.
Nor the defense. Thank you.
Thank you, you're all set.
Thank you.
No problem. Shakir Jameson Rogers, are we running that? I'm sorry?
I haven't seen him yet.
You haven't seen him yet. Have you spoken to him? Recently?
Since he went to the hospital last time.
Oh, boy.
His mom.
We're running Mcfaden. We don't know where Mr. Rogers is. Oh, he's not in jail? Put a jail tag on there. Oh, okay.
I'm already on Clark, Judge, the waiver of the 21 days.
Thank you.
Okay, Young is gonna be a plea?
Yes,
A
sir.
felony plea though?
Yes, sir. Paperwork's already been filled out.
Okay, and then Marius Clark is present.
Yes, Your Honor.
On the record in the matter of the people of the state of Michigan versus Marius Clark, file number is 23-03550. FY, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender from the City Court.
Thank you. Today is the date and the time that's set for a preliminary examination. How are we proceeding on this, council?
At this time, Your Honor, I believe it will be a waiver for 21 days. I believe defense is looking to acquire some additional discovery. People would have no objection to the waiver.
That's correct, Judge. We're willing to waive the 21-day timeline.
You're seeking additional discovery?
We are.
Okay. What is the discovery you're seeking?
We're hoping to get some surveillance footage from the alleged incident location.
Okay, and Mr. Clark, you understand that you have the right to have a preliminary examination within 21 days of the date that you're arraigned.
Yes, ma'am.
And due to the pending discovery being sought, are you willing to waive that timeline so we can reset this?
Yes, ma'am.
Anybody threatening you to get you to do that?
No, Your Honor.
Okay. February 8th at 10:30. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
Okay, bond will continue. We'll get you your notice to appear, okay?
It's at 10.
10:30, that's
Thank you.
correct. No problem. Mr. Palmer, is Lyman Hunter here?
He is, Judge. I can grab him. It'll just be a waiver of exam.
Okay, sounds good. You can grab
Would you
him.
like me to grab him now?
Yes, please. On the record in the matter of the people of the state of Michigan versus Lyman Hunter IV, file number 23-02858, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Thank you. Good morning, Your Honor. Robert Palmer, of the Public Defender's Office, on behalf of Mr. Hunter, the gentleman standing to my right.
Okay, today was the date and the time that was set for a preliminary examination. Looks like we did wait 21 days previously so that there could be an expiration of a global resolution. And now the parties want to unconditionally waive the exam. Is that correct?
That's correct.
That is correct, Your Honor.
Okay. And the global resolution does not involve another case that's here, does it?
Judge, I can give an explanation. Mr. Hunter has a pending misdemeanor that is here at 54A. There's also, as of now, an uncharged file. The idea is that Mr. Hunter will waive his preliminary examination today, find over to the 30th Circuit Court for entry of a plea at that level. My understanding is, first of all, he's 19, so I guess we don't need a consent from the prosecutor's office, but my understanding is that there would be an agreement for HYTA status on that. And additionally, as part of that global resolution, the people are agreeing not to charge that other felony. And I do want to make that clear because the one concern I have in all of this, I suppose, is that I don't want the other felony to be charged between now and the time we get up there. I would rather, obviously, my client not be arrested on some warrant that he doesn't know about. So I can't do anything about that per se. That's the prosecutor's office part of that, but that's the agreement that we use.
Use of violence.
Yes, Your Honor, that is a fair and accurate statement of the agreement. My internet is acting up right now, so I can't get verbatim what it was, but yes, that is the understanding of the agreement, and there are notes in the files that this is what the agreement is. So that should not be charged. That, I guess, the pending file should not be charged before this matter has been resolved. And then that will just be declined by our office at that time.
Okay, sounds good. And so, Mr. Hunter, how are you?
I'm good.
I'm doing well. And so you understand that you have the right to have a preliminary examination in this file here in the district court?
Yeah,
Do you understand the purpose of the preliminary examination?
yeah.
So you have the right to require the prosecutor to put forth evidence at the preliminary examination that support that they have sufficient probable cause that a crime was committed, and then probable cause sufficient to charge you with the crime. Do you understand that? Do you wish to unconditionally waive your examination? Anybody threatening you, Mr. Palmer? Anybody threatening you to get you to waive it? Has there been any promises made to you that are getting you to waive your exam?
No.
So you're waiving it freely and voluntarily?
You have to speak up a little bit.
You have to speak up and use words. I don't know why people say yeah, yup.
I
Nope.
say yes.
Yes and no. Thank you.
May I approach, Your Honor?
Yes. Okay. Find your waiver to be freely and voluntarily made. The bind over date's gonna be December 20th, so that's the date the circuit court gets the file from the district court, okay? You do not have to appear in court on that date, okay?
All right.
Your next court date will be a pre-trial in the circuit court. Mr. Palmer will be made aware of that date. Has your address changed since you were arraigned?
No, it's still the same.
Okay. Your bond in this matter was set at $750 personal recognizance, and that will continue. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the defense, Judge. Thank you.
You're all set.
Thank you.
Thank you. Have a good one.
Same to you. Where is his attorney?
Yeah.
On the record in the matter, the people of the state of Michigan versus Louis de Huelves, file number 23-03533, council appearance.
Jeff Reynolds on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, and on behalf of Louis Deloz, who's president, walking over to my right this morning. Your Honor.
That's Louis de Huelves Jr., correct?
Yes, Your Honor.
Okay, today was the date and the time set for a preliminary examination. I have here. People are offering for the defendant to plead guilty to an added count 3 of aggravated assault, and the people will dismiss counts 1 and 2. Is that an accurate understanding of the plea offer?
It is.
It is, Your Honor.
You want to accept that, sir?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Okay, I do have an advice of rights and plea information sheet. Has today's date on it. Is that your signature?
Yes, Your Honor.
Did you read this document?
Yes, Your Honor.
You understand the rights listed here?
Yes, Your Honor.
You want to give up all of these rights today?
Yes, Your Honor.
You understand that you have the right to proceed to trial in this matter?
Yes, Your Honor.
You have the right to jury trial, and at the time of trial, you have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecutor to prove your guilt by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to confront in court and cross-examine any other witnesses the prosecution intends to call. You have the right to call your own witnesses to trial or present evidence that you believe further defense to the charges being brought against you. You have the right to remain silent and not have silence be used against you. Do you understand that?
Yes, Your Honor.
Anybody threatening to get you to give up all of those rights?
No, Your Honor.
Any promises being made to you in exchange for a guilty plea today?
No, Your Honor.
Are you currently on probation or on parole?
No, Your Honor.
Are you being held on anything other than this matter?
False information.
Okay. And you understand that a guilty plea could result in a conviction that you may need to report to your future employer or to a current employer?
Yes, Your Honor.
You understand that a guilty plea can result in a conviction that may have impact on travel or immigration status you may be seeking?
Yes, Your Honor.
As to the added count 3 of aggravated assault, how do you plead?
Guilty.
Are you pleading guilty because you believe you're guilty?
Yes, Your Honor.
Factual basis.
Yes, Your Honor. Mr. Deloz, I want to turn your attention back to November 20th of 2023. Were you at 1319 Jerome Street?
Yes, sir.
It's here in the city of Lansing,
Yes, sir.
Ingham County, state of Michigan.
Yes, sir.
And there, Mr. Perez Santana lives there, is that correct?
Yes, sir.
He's somebody that you know, is that correct?
Yes, sir.
And you were asking him for if you could stay there, is that correct?
Yes, sir.
And you were staying there for a little while, is that correct?
Yes, sir.
And then an argument ensued, is that correct?
Yes, sir.
And from there you grabbed the knife, is that correct?
Yes, sir.
And what'd you do with that knife?
I drugged him with it, told him to stop hitting me.
So you're using that knife as a to stop a fight, but you could have used your hands in self-defense as well, is that correct?
Yes, sir.
And did you hit Mr. Perez Santana with a knife?
He had grabbed the knife with his hand, so yes, sir.
Okay. Your Honor, I have no additional questions for Mr. Deloz, Your Honor.
This factual basis is that he used the knife to stop someone from hitting him?
Correct, arrest, but you can't use a knife in self-defense. You guys got an arm. Can't use a weapon.
You pulled the knife, or you already had the knife in your hand?
Your Honor, I pulled the knife.
You pulled the knife, and this was after he assaulted you, you pulled the knife?
Yes.
Okay. Any further questions?
Nothing from the people, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea if I plea be made freely, voluntarily, and intelligently. This matter will be set for sentencing. Your sentencing date is going to be February 1st, 2024 at 9 o'clock in the morning. You need to meet with probation so they can provide the court with the pre-sentence report and recommendation. He's only being held on this matter?
As well as he has a few matters with the city, Your Honor.
Oh, okay, but he's not being held on those, correct?
That's correct. Your Honor.
So on the city matter, yeah, but their PR after 14 days. So he's not being held on that.
Correct, Your Honor.
Okay. We'll make sure that probation knows that you are currently at the jail. If you do bond out in between now and February 1st, you need to make sure you report to report to probation within 48 hours so they can get you set up for your interview, okay?
Okay.
Do you have any questions?
I don't, Your Honor.
Any additional matters for the record?
Nothing from the people.
I presume you're not going to give this client a PR bond, Your Honor, is that correct?
I will give him a PR bond. I didn't know you were gonna make a motion.
Yes, Your Honor.
Okay, I'll amend his bond to 5,000 personal recognizance. You need to report to probation
Yes, Your Honor.
within 48 hours of your release, okay?
Yes, Your Honor.
So I'll say here your report to probation by Monday at 10:30.
Yes, Your Honor.
If you don't, then a warrant will issue, okay?
Understand, Your Honor.
Do you have any questions?
I do not.
Any additional matters for the record?
None, Your Honor, thank you.
Nothing.
You're all set, thank you.
Yeah, I gotta type over the bond, so I'll bring it down, so I gotta do a whole.
Okay, are we ready to proceed on Mcfaden?
Yes, I believe so, Your Honor.
Are you ready or do you need time?
Just 1 minute.
Mr. Pfeiffer, you're waiting on who?
Young.
Custody, and there's Wanji's case, but she's gone over advice of rights, and we had the felony plea paperwork all signed. Filled out.
I'm sorry? Yes, please.
All right.
What's his name? Thank you. I spell it wrong every time I try and type it.
Okay, on the record in the matter of the people of the state of Michigan versus Ostiano Young, file number 23-01786. Council appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good afternoon, good morning, Your Honor. May I need one check from Mr. Ostiano?
Okay, today was the date and the time that was set for a preliminary examination. I do also have a PA 53 violation, which was addressed in some form on the record last week, alleging violation of the bond conditions from the Ingham County Jail.
Yes, Your Honor. After discussion with defense counsel, we have reached a felony plea agreement. As part of the agreement, the people will also be requesting that this court dismiss the PA 53. We think that is appropriate, fair offer, as the agreement is for the defendant to plead guilty to felony domestic violence third offense, that being count 2. And because he's pleading at the district court level before that is addressed, there is agreement to a county cap. The people would dismiss count 1, would agree not to pursue witness interference charges for contacts made prior to 12/6/2023, and be requesting that this court dismiss the PA 53 allegations.
Okay, do you have a plea sheet?
Yes, Your Honor. It's with the felony documentation that I handed to court staff.
Okay, so the offer again is for you, Mr. Young, to plead guilty to an added count 2 of domestic violence third offense.
Yes, Your Honor.
There's a kilogram to a county cap, and that the people will dismiss count 1 upon successful plea and sentence, and agree not to pursue the witness interference for jail contacts prior to 12/6/2023, and agrees to request that the court dismiss PA 53 allegations, and that those be discussed. That's your understanding of your plea offer?
Yes, ma'am.
You want to accept that offer?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Okay, so you're being charged with felonies in this matter. You understand that you have the right to have a preliminary examination? You can put your hand down. You have the right to have the preliminary examination within 21 days of the date that you're arraigned, and you have the right to require the prosecutor to meet their burden of probable cause. So they have to establish at the examination that they have sufficient probable cause that a crime was committed, and then probable cause sufficient enough to charge you with those crimes. You understand that? You understand that, right? You want to waive that right? Anybody threatening you to waive your examination? Has there been any promises made to you to get you to waive your examination? Excuse me, can you speak up?
Yes, ma'am.
Anybody make any promises to get you to waive the examination?
No, ma'am.
Okay. Okay, so we'll bind the matter over to the jurisdiction of the circuit court. And now acting in circuit court capacity, we've already addressed the fact that there will be a circuit court plea today in the district court. And Mr. Pfeiffer, you do consent to that, correct?
Yes, Your Honor.
Okay, and so Mr. Young, you have the right to be sentenced by the judge that takes your plea, but in this case, I would take your plea, but you will be sentenced before a circuit court judge. You understand that? Okay, do you consent to that? Ms. Wanja, you consent to that?
Yes, Your Honor.
You consent to that, Mr. Pfeiffer?
Yes, Your Honor.
Okay, and the court has already bound this matter over to the circuit court, but the formal information will not be filed until later. The plea today will be on the reading of the complaint or on the complaint as amended. Do you waive the right to have the information provided to you today as long as it substantially complies with the reading of the charges here today? I need you to speak up so the record hears you. Okay. Ms. Wanji?
Yes, Your Honor.
Okay. Okay, and again, Mr. Pfeiffer, the counts that you want the defendant to plead to is count 2 of domestic violence third, correct?
Correct, Your Honor.
Okay, and Mr. Young, do you waive the reading of count 2 of domestic violence third?
Waive the reading of count 1.
Of count 1, that is, you waive the reading of count 1? Okay. So waiving the reading of count 1, count 2, again, is charges domestic violence. That's a third offense notice alleging that you didn't make an assault or an assault and battery upon Breonna Jackson, an individual with whom you had a child in common, or an individual with whom you had a dating relationship, and that this was contrary to Michigan compiled law 750.812. Restitution may be ordered as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. Because there's a third offense notice, it's typically a misdemeanor, maximum penalty 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. But this is charged as a third offense notice, indicating, take notice that the defendant was previously convicted of assaulting or assaulting and battering his or her spouse, former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his or her household, or of knowingly assaulting a pregnant individual by violating MCL 750.812A2 on or about February 18, 2021, and by violating MCL 750.813 on or about October 21st, 2021, and therefore upon conviction will be subject to enhanced sentence under MCL 750.815 that enhances the penalty to a felony. Maximum penalty 5 years and or $5,000 in fines. Again, a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement, and if this offense resulted in damage to another individual's property or physical injury or death to another individual, restitution may be ordered. As to that count, which is count 2, Mr. Young, how do you plead? You understand again that this count carries a maximum penalty of 5 years in prison and or $5,000 in fines.
Yes, ma'am.
Are you currently on probation or on parole?
No, ma'am.
And you understand the rights that you have to give up in order to move forward with a guilty plea? Okay, can you let me finish the question before you respond? Thank you. Okay, and so I do have an advice of rights here There's a signature on the bottom. That's your signature,
Yes, ma'am.
and that's the date for today. Did you read this?
Yes, ma'am.
You understand each of these rights?
Yes, ma'am.
Okay, so you understand that if your plea is accepted, you will be giving up each of the rights, including the right to be tried by a jury, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove each element of the charge being brought against you beyond a reasonable doubt.
Yes, ma'am.
I'm sorry, I have IT logging into my computer right now. Okay, you also understand that you would have to give up the right to have witnesses appear at trial against you. You would give up the right for the court to order any witnesses that you wanted to testify and to further your defense to the charges to come to trial. You're gonna give up your right to remain silent and not have silence be used against you. And you're gonna give up the right to testify if you want at your own trial. You understand that?
Yes, ma'am.
You can also give up any claim that the plea was the result of promises or threats that were not disclosed here today. You recognize that?
Yes, ma'am.
Anybody threatening you or making any promises to get you to plead guilty today?
No, ma'am.
If your plea is accepted, you may also be giving up your right to appeal the issues that would have otherwise been appealable if you were convicted at a trial. Do you understand that? And we've already stated any agreements as it relates to the plea in this matter on the record. And we've already indicated that that was a complete and accurate understanding by both parties. And as to count two, have already entered your guilty plea. Can I have a factual basis?
Yes, ma'am. Mr. Young, on April 15, 2023, were you in the city of Benson? And it's England County to the best of your knowledge, correct? And at that time, you had contact with Miss Brianna Jackson. Miss Jackson is the mother of your child, correct? And
Use your outside voice for me, Mr. Young.
Yes, ma'am.
And well, she's the mother of your children.
Yes, ma'am.
And at that time, did you touch her without her permission?
Yes, ma'am.
And it was an offensive touch, correct?
Yes, ma'am.
And you have already been convicted of assault and battery. That was last year.
Yes, ma'am.
And actually you spent a year in jail.
Yes, ma'am.
And you understand that because of that conviction, that makes this domestic violence 5 years. And I think that I have enough.
Mr. Pfeiffer,
I don't believe there is enough. If I could ask just a
please.
couple lawyer questions. The assault and battery you're convicted of last year, that being, sorry, not last year. Is it true that you're convicted of domestic violence October 21st, 2021?
Yes, sir.
And isn't it true you're also convicted of domestic violence on February 18th, 2021?
Yes, sir.
Thank you. People have no further questions.
Okay. The court is satisfied with the factual basis and we will accept your felony plea as to count 2 of domestic violence 3rd offense. The court's also going to indicate on the record that the court has not agreed upon any sentence with anyone involved in this case. Counsel, are you aware of any promises, threats, or inducements for this plea other than what was disclosed on the record?
No, Your Honor.
No, you're not.
And counsel, has the court complied with Michigan Court Rule 6.302 and the local administrative order allowing a felony plea in the district court?
Your Honor, I believe the court has complied with the rules.
The court has, Your Honor.
I find the plea to be made freely, voluntarily, and intelligently, and I find the plea to be accurately and understandingly made. Your plea is accepted and the case will be transferred to Judge Joyce Dragonchuck for a sentencing date of I might have missed those. I have March 4th, 2024. And the circuit court case number will be 23-000-883-FHC30. Any additional matters on today's record for this item?
Only to confirm that P 53 violation is dismissed in this case.
The PA 53 violation will be dismissed, and then Mr. Young will need to report to pretrial services and probation at the circuit court, okay?
Thanks. One other matter that I just make sure is placed clearly on the record after every plea that I take, which is that one of the only things that can lose Mr. Young the benefits of this plea deal is if you were to violate an order of this court between now and his sentencing date, which would include the no contact order. If that were to happen, you'd not only be stuck with the guilty plea entered today, but he would lose out on the benefits of it, such as the 1-year county cap. I just want to make sure that is crystal clear for Mr. Young.
Mr. Young, do you have any questions?
No, ma'am.
And the people have nothing further.
Thank you. Any additional matters, counsel?
I know, Your Honor, and I did explain to Mr. Young, the consequences of plea violating the condition of the bond.
Very good.
Thank you, Your Honor.
Thank you. You're all set.
Thank you.
Your Honor, have a good weekend and a good holiday.
Same to you.
Judge, we'll bring it first.
We're going to do Mcfaden first, so no, not right now. the record in the matter of the people of the state of Michigan versus Ralph Mcfaden, file number 23-03362, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, I'm gonna need you on it, Mr. Mcfaden, this is here the council people.
Okay. Today was the date set for preliminary examination. Are we ready to proceed?
Yes, we are, Your Honor.
Yeah.
Okay. Do we have any preliminary matters that we need to address before we call in our witnesses?
Just one, Your Honor, if I may, I would like to present to the court what has been marked as People's Exhibit 1, or I should say proposed Exhibit 1. What I believe will be admitted as People's Exhibit 1 is a certified copy of conviction for Ralph Dante Mcfaden from the 30th Judicial Circuit. If I may approach, Your Honor.
Yes, and you've already shown Ms. Warren.
Yes.
Okay, and are we stipulating to that?
Just for the preliminary on this one.
People's Exhibit 1 is admitted. Any other preliminary matters?
Sequestration of witnesses.
Sequestration is granted. How many witnesses do you have?
2, Your Honor.
Are they both officer witnesses?
Yes, they're both MSP troopers.
You can call your first witness.
I thank you, Your Honor. People would call Trooper Luke Shaver.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury. Thank you, officer. You can have a seat. Trooper, if you could spell your first and last name and spell them both.
Yep, Trooper Luke Schaefer, LUKESHAFR.
Please proceed, counsel.
Thank you, Your Honor. Good morning, Trooper Shaver.
Good morning, sir.
Trooper, how are you employed?
With the Michigan State Police.
And how long have you been with the Michigan State?
Since June of 2019.
Okay, and were you working in that capacity on November 7th, 2023?
I was.
And what capacity were you working in at that time?
I'm assigned to the Secured City Partnership. We work in conjunction with the Lansing Violent Crimes Initiative.
Okay. And what were your duties that day specifically, if you remember?
So just a typical road night for us out in the city. We do surveillance, work, anything gun related, drug related, as kind of the higher end felonies.
Okay. And at some point that night, did your duties take you to 3325 South Martin Luther King Boulevard?
Yes.
And do you remember what location that is?
Yes, it's the Royal Liquor.
Okay, and is that location in the city of Lansing?
It is.
In Ingham County?
Yes.
And why were you at that location?
So that's a known hotspot for us. I was sitting across the street conducting surveillance. It's just, like I said, a hotspot for guns and drugs and stuff like that.
Okay, and while you were conducting surveillance, did you notice anything at that time?
Yes, so we sit across the road, blacked out, so our lights are off, utilizing binoculars. Saw the defendant walking from the south end of the store or the building. He was walking up, he had his left hand in his top hoodie pocket, his right hand was in a secondary hoodie pocket that was underneath the top one. He's holding an object.
Okay, and why was that noteworthy to you?
So just based off my training experience, like I said, that's pretty much what I do in the city is we go after violent offenders, gun cases, drug cases, stuff like that. So when the subject was walking up from the south end of the building with that front hoodie pocket with his left hand in it, clearly I could see there's nothing in there. It's odd that there's his other hand was inside of another hoodie pocket grabbing onto something. As he's walking up, he's constantly looking around. Based off my training experience, that's characteristic of someone carrying a firearm.
Okay, and did you continue to watch this subject?
Yes, so he went into the store, He was in there a couple minutes, came out of the store. When he came out, it was the same thing. He had his right hand, that secondary hoodie underneath the top hoodie, grabbing onto something. He continued to walk northbound. At which point, once he reached the end of the building, he kind of went eastbound through the parking lot. So,
And so did you have visual of the subject this whole time?
yes,
Okay.
except for when he went in the store, I can't see him there.
Okay, and so you said the subject went, I believe you said eastbound through the parking lot. Was that the parking lot of the liquor store you were watching, or was that a?
Yes, so it's the Royal Liquor. Little Caesars is just north of it in that same building. When you reach the end of that building, Little Caesars is on the end. He walked eastbound, pretty much between Burger King and where the Royal Liquor is.
Okay, and what did you do at this time?
I relayed the information to some of our undercovers, just to have them do a drive-by so I can get a better understanding, to see how he acted. When one of the undercovers drove by, the defendant pinned his arm, which is another common style to keep the firearm secured against his body. So he did that. Once the undercover drove by, he was looking over his shoulder. He readjusted with his right hand the object that he was holding on to. And we call it kind of like a security check.
I'm gonna stop you. Did you observe this?
Yes, so I'm still sitting across the street, utilizing binoculars.
Okay, so you observed what he was doing when the undercover drove by. Is that what you're testifying?
Yes, so I had the undercovers drive by just to see how he would act.
Okay.
At this time, I hadn't moved my car, and I could still maintain eyes.
Okay, thank you.
Thank you, Henry. That was actually gonna be my next question. So you see the undercovers drive by, you see the subject do this. What did you do at that point?
So after the undercovers drove by, he did the arm pin. The undercovers kind of left the area, the immediate area. Subject adjusted the object he was holding on to with his right arm, kind of loosened his stance from like the pin to his tight to the body, keeping that object secured. So he loosened up his arm, looking over his shoulder, and that's what we call security checks. It's just, making sure the gun's there, and then keeping an awareness around.
And what did you do after that?
So I utilized two undercovers at that point to maintain eyes on him. I knew the direction he was traveling, so I exited out of the parking lot I was sitting in, traveled northbound MLK, got up to Southland, and took an eastbound turn on Southland to get in front of the defendant. During this time, we had maintained radio contact with our undercovers that positioned themselves so they had eyes on at all times.
Okay, and did you ever make contact with the subject?
Yep, so I came around Southland and Washington area in that parking lot in the corner. Once he was almost to that open area, that's when I moved my patrol car in front of him. Didn't activate my lights or anything like that to make contact with him at this point. And like I said, the undercovers had eyes on him and us the whole time.
Okay, and when you approached the subject, what happened at that time?
He became nervous. He was talking really fast, talking with his hands, said he was just coming from the store, and then continued to try to walk away. So as a de-escalation thing, clearly he didn't want to talk to me. Trooper Black arrived in a secondary car. Trooper Black began speaking to him while I was sitting right there.
Okay, and you said you confronted him, I believe, in a parking lot. Do you recall what business that parking lot was associated with?
It's like the axe throwing business. Okay. It's like that parking lot that edges up to Washington, Southland area.
Okay, but was that location still in the city of Lansing?
Yes.
In Ingham County?
Yes.
Okay. And during your interactions with the, after you stopped and approached the subject, did you ever identify the subject?
Yes.
And did you ever learn that subject's name?
Yes,
And do you recall that name?
yes, it's Ralph Mcfaden.
Okay, and do you see Mr. Mcfadden here in the courtroom today?
I do.
And can you please identify where he's sitting in an article of clothing he's wearing?
I sitting right there with a black jacket on.
Okay, please let the record reflect the witness has identified the defendant.
Any objections to identification?
Not for the purpose of the preliminary examination.
Identification is noted.
No other questions at this time, Your Honor.
Cross-exam.
Thank you. Good morning.
Trooper.
Jefferson. When you observe my client, he went to different stores that day, correct?
So like I said, he came up from the south end of the building. I watched him walk into the Royal Liquor and then he came out of the store.
You did not observe him going to the weed store?
No, I didn't. He
Okay.
told me later on that he was there.
Okay. So it's possible if he went to different stores that he bought stuff, correct?
I don't know what you're asking. I
Well,
would assume-
it's possible that if he went to the stores, he may have bought things.
Yes.
Okay, so you observe him and he had his hand inside the second hoodie, so that's what he testified.
Yes.
And so it's possible that if he bought items in the store, he would have put those items in his hoodie pockets, correct?
He could put them in any pockets.
Okay, and you did not observe, it's your testimony, you did not observe that what he had in his pocket had the form of a gun. Is that correct?
Can you ask that again? Sorry.
I want you to repeat the question.
Yeah.
What you observe him holding, you did not testify that he had the form of a gun.
Yeah, I couldn't see it was a gun holding on to something.
You could see it's a gun. That's what you say now?
No, I just said I couldn't see a gun. I saw he was holding on to something.
And he was holding something heavy.
Yes.
And you agree with me that if he had bought, for example, liquor in the store or at somewhere else, he could have put that in his hoodie, in the pocket. Is that correct?
Object at this point, ask and answer, Your Honor.
She didn't, she just asked me if he had bought liquor.
I don't know what.
She's not asked that question. Well, I gotta address the objection. She asked if there was, specifically, if he had purchased liquor, could that have been, what was the end of your question?
He could have put it in a.
Okay.
I mean, it's a
I have, officer, so if there's an objection, I have to address it, and then I'll tell you if you can give that answer. or
Oh,
not.
okay. Sorry about that.
Okay, and so, as to that specific question, it is close to the other question, but she did, make it more specific, so I'll allow it, so I'm gonna overrule the objection. You can respond.
Okay, thank you. Yes, it's a possibility.
You also testified that the reason why you were at that place is because it's a hotspot. Okay.
Yes.
Hotspot for what?
Guns, drugs, stolen cars. I mean, we did a lot out of it.
And you do understand that the people in that neighborhood also believe that it's a hotspot, correct?
I don't know what people think.
Well, if it's a dangerous spot, it's dangerous not only for the police, it's dangerous also for people who live in that spot, in that neighborhood. Would you agree with me?
I mean, yes.
So people who live, if you live in a dangerous neighborhood, it's possible that it's even reasonable that when you're walking, that you look around you. Would you agree with me?
Yes, that's why there's more that goes into it. Like based off my training experience, like I testified earlier, it's not just the one thing, it's multiple things, kind of the totality of the circumstances. So everything that's adding up, it's just trends that we see, that I've learned in training, stuff like that.
Okay, let's go one by one.
Yes.
Hotspot, it's not just for you, it's also for the neighborhood. Is that correct?
We call it a hotspot because of the stuff we get out of there. But yes, I mean, people frequent that store that we see multiple times.
Okay, and it's you also testified that it's possible that what he had in his pocket could have been something else but a gun.
I mean, yeah, it could be anything.
Okay, so and you also agree with me that for people who live in a neighborhood, if the neighborhood is dangerous, they may tend to look around them when they're walking. Will you agree with me?
Yes.
Okay. That day, you did not observe Mr. Mcfaden commit a crime when he went to the store, the liquor store, is that correct?
No.
You did not observe him commit any crime when he was walking and you were surveying, you had him, you were looking at him, is that correct?
Yeah, that's why I didn't turn on my lights. I just made contact in the parking lot with him.
Okay, so when you make contact with him in the parking lot, you made contact with him and you say that he did not really want to talk to you.
Yeah, like I said, he said he was coming from the store. He was talking with his hands, continuously talking. I didn't really get the chance to get anything out, at which point, like I said, to de-escalate situations. If someone clearly doesn't want to talk to one of us, the other person will step in. So that's when Trooper Black was there. Trooper Black, when I was standing right there, he asked him if he had a CPL. He didn't answer. And he said, hey, we know you have a firearm, at which point he had admitted he had a firearm on him.
Well, not refusing to talk to you when you have not done anything is not a crime. Is that correct?
No, that's why we didn't turn the lights on. We didn't jump out and put him in handcuffs. It was just a contact that we were having with him.
He told you that he was going back home to his home.
He said he was coming from the store and
he
like
was
I
going
said,
home.
I don't recall what he said.
Coming to the store. Okay, coming to the store is not illegal.
No.
When you say he did not really want to talk to you, he did answer the questions that you asked him.
Like I said, so him continuously talking, the talking with his hands, just the nervous behavior, and continuously walking. It just, like I said, it goes into the totality of the circumstances for us. So at that point, like I said, Trooper Black took over, asked him if he had a CPL. He didn't answer. Then Trooper Black asked or advised he knew he had a firearm on him, and he admitted he did.
Now you were here. You heard Trooper Black ask him if he has a firearm, correct?
Yes.
And for you not answering that question, or what did you believe? What did he do when Trooper Black asked him if he has a firearm?
He advised he did.
Okay, and he did not. So that was the first answer. Yes, I have a firearm.
So like I said, he asked him if he had a CPL.
Okay.
He didn't answer that question. Trooper Black said, hey, I know you have a firearm on you, which he ended up admitting he did.
The place that when you were the place that you were looking at and you were the hotspot has a lot of people walking around. Is that correct?
Yes.
And that day there were a lot of people walking around.
I don't recall like the foot traffic at that given point in time, but it varies throughout the night. That's why we sit there for hours.
Is it the truth that when you approach him, you touch him first?
Touched him?
Yes.
I never touched him until he knew he had a firearm.
You don't, is it the truth that you don't go around and ask people if they have a CPR?
Well, there's been numerous times there where we see the same characteristics of it. The same things I've explained to you, where we'll make contact with them and we ask them, hey, do you have a CPL? And they say, yes, I do. and I have a firearm on me, they'll tell us right away. There's also been times where we see characteristics and we go up and talk to people and they're completely fine with us and they don't have a gun. So it's just certain things, like you said, it's the neighborhood, people are looking around, still kind of helps build a reasonable suspicion to make contact with people, that have a conversation. It also builds community relations.
We already, okay, so let me ask you, you said that he was acting nervous,
Yes.
and if you're not surprised that the black man, when approached by the police, looked nervous, correct?
I don't know how you want me to answer that.
Yeah, well.
The question was, are you surprised?
Are you
So yes or no?
No, I mean, doesn't matter what color your skin is, what religion you are, I treat everyone with the utmost respect. And if they give it back to me, everyone's perfectly up and fine. I mean, I get called names on the daily and I have to sit there.
Okay,
well,
there's been no objections, but some of this stuff is not responsive. So you have to answer the question and only the questions that are on the table, okay?
My question was, you're not surprised if you're a black man when he sees the police looking nervous?
He answered that.
I have no further questions for that one.
Redirect.
Thank you. Just briefly, Your Honor. So Trooper Schaefer, you said you were sitting there observing that for hours at that point?
Every night depends. If we're not working with BCI or if we're not up on certain targets, stuff like that, we go out and do our own thing and we can talk about it.
And on that night, how long had you been watching that, if you recall, that spot?
I mean, I don't recall how long we were there before that, but usually what we'll do is we'll stop the car, go back to that spot. So it's just a revolving door that we sit there.
And prior to seeing Mr. Mcfaden acting in this manner, had you observed anybody else acting in that manner or that you recall?
Not at that time, no.
Okay. But you did state, I believe, that you've seen that type of behavior before, correct?
Yes, multiple times.
And that on occasions and have you stopped people before who had that type of behavior?
Yes.
Okay, and have some of those people had firearms on them?
Yes.
Okay. And just, I know you said, just to clarify really quick as well, I know you said that between, at some point you had BCI officers, undercovers watching Mr. Mcfaden, correct?
Yes.
And was the individual that you approached in that parking lot the same individual you observed initially at the Liquor King?
Yes.
Or Royal Liquor, I believe?
Yes.
Okay. And then at the point when you began to question Mr. Mcfaden, had you placed him under arrest or done anything like that at that time?
No.
Okay. No other questions, Your Honor.
May this witness be excused?
Yes, Your Honor.
Thank you, Trooper Schaefer.
Thank you, Your Honor.
Call you next. Oh, let me advise you, there's a sequestration order, so you can't discuss any portions of your testimony with any other witness, okay?
Yes, Your Honor.
Thank you. You can call your next witness.
Thank you, Your Honor. People would call Officer Cody, or sorry, Trooper Cody Black.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, ma'am.
Thank you, Trooper. You can have a seat.
Thank you.
And can you spell your first and last name and
It's
say both of them for us?
Yep, it's Cody Black. The first name is spelled C-O-D-Y. The last name is spelled B-L-A-C-K.
Thank you. You can proceed, counsel.
Thank you, Your Honor. Good morning, Trooper Black.
Good morning.
Trooper Black, how are you employed?
I'm employed as a trooper with the Michigan State Police. Currently, I'm assigned to the Spirit Cities Partnership.
Okay, and how long have you been a trooper with the Michigan State Police?
Approximately 4 years.
Okay, and were you working in that capacity on November 7th, 2023?
I was.
And at some point, did your duties take you to a parking lot that night, I believe by the Cube Smart
Yes,
building? Okay, and was that location in the city of Lansing?
Yes, sir. it was.
In Ingham County?
Yes.
Okay. And what caused you to be at that location that night?
We were working in conjunction with VCI, which is Lansing Violent Crime Initiative that night. My partner, Trooper Schaefer, stated he observed an individual who was exhibiting characteristics of carrying a firearm. So we decided to make verbal contact with him and go from there.
Okay, and did you make contact with that individual in that parking lot?
I did.
Okay, and what happened when you, so you stated your partner, Trooper Schaefer, were you guys were you working in separate cars, the same vehicle?
We're in separate vehicles, but we communicate over the radio together.
Okay. So when you arrived at that location, what did you observe?
When I exited my vehicle, my partner, Trooper Schaefer, was speaking with Ralph Mcfaden. At that time, I noticed that Ralph was trying to walk away from him. At that point, I observed the L-shaped pistol that was located in his front hoodie pocket. So at that time, I asked him if he had a pistol on him, and he said he did.
Okay. And you stated you saw the imprint of the handgun in his hoodie?
Correct. Yes, sir.
Okay. And have you seen handguns in hoodie pockets before?
Plenty of times, yes,
sir. And did you ask the, so did you identify the subject?
After the fact.
Okay.
Yes, sir.
Do you recall the name of that individual? I think you already said it.
Yes, sir.
Okay, and do you see Mr. Mcfaden here in the courtroom
I
today?
do. Yes, sir.
Okay, and can you please indicate where he's sitting in an article of clothing he's wearing?
He's sitting next to his attorney. He's wearing a black jacket with a white shirt.
Okay, please let the record reflect the witnesses identified the defendant.
Insufficient objection at this time?
No, you're not.
So in your interaction with Mr. Mcfaden, did you ask him anything else at that point?
I asked him if he was carrying a gun. Initially, he didn't answer me. He put his head down, and then I said, "I know you have a pistol on you." He said, "Yes, I do." At that time, he tried to reach for it. I grabbed his arm and said, "No, I'll grab it from you,"
Okay.
in order to prevent him from grabbing that pistol.
All right, and did you recover anything from Mr. Mcfaden that night?
Yep, the pistol from his front hoodie pocket. It was loaded with a round in the chamber and a magazine with ammunition.
Okay, and what happened after you recovered? Can you describe that firearm for the court?
I can't remember the brand or the model number. I know it was
Okay.
Your voice dropped, you know, it was what?
a black pistol, ma'am.
Okay. And what happened after you recovered that firearm?
I made it safe. At that point, I conducted an interview with Ralph after I read his Miranda rights.
Okay. And what did you learn from Mr. Mcfaden at this time?
After speaking with him, he said that he was walking to the liquor store when he located a pistol that was on the ground. After he left the 3200 South Washington address, or I forgot the name of the apartment complex there. I know it's in my report. But he said he found it, and at that time he possessed it. And he said prior to that, it hadn't belonged to him. He had just found it on the ground.
Okay. And did he say anything else at this time during the interview that you recall?
Not that I recall. If I could direct or look at my report if I need to.
1 second. Yeah, so Trooper, if you saw your report, would that refresh your recollection as to your interview with Mr. Mcfaden?
Yes, sir.
All right. Permission to approach her?
Yes.
And so if you could just. And then look up. Mr. Procure.
Yes.
Trooper, did that refresh your recollection?
Yes, sir, it did.
Okay, and so did Mr. Mcfaden tell you anything else when you interviewed him?
Yes, I asked him if he knew he wasn't allowed to possess a firearm. He said he was aware he was not allowed to possess a pistol because he was a felon. Then I asked him why he carried the firearm and he said he was concerned for his safety.
No further questions, Your Honor.
Person Sam.
Good morning.
Good morning.
You stated that you, Mr. Cooper Ralph is the one who advised you of my client having some.
I missed that first part, I'm sorry.
Cooper Schaefer is the one who advised you of having seen my client with some characteristic of someone who has a gun.
He indicated that someone walked into the Royal Liquor Store and then walked back out exhibiting characteristics of someone that would carry a firearm.
Okay. And he did not say that what he observed was the imprint of a firearm, correct?
No, I observed that.
And you observed that when you got to my client, Cooper Schaefer was already talking to him.
I mean, he had made initial contact with him, but I exited my vehicle, which is obviously not the vehicle he's in, and made my own observations.
Okay. Isn't the truth that when you got out of the car, both of you jumped on him and asked him if he has a gun?
I don't know what Trooper Schaefer asked him. Like I said, I wasn't next to him at that point in time. I know when I exited my vehicle, I made my observations that he had a L-shaped firearm in his hoodie pocket. And so I specifically asked him if he had a gun.
Okay. Now, when you ask him if he has a gun, he respond that he does have a gun, correct?
Correct.
Are you familiar with the Fifth Amendment?
The Fifth Amendment?
Yes.
Yes, ma'am. I don't, just self-incrimination? Absolutely.
Yeah. Okay. So when you asked him that question, you did not advise him of the consequences of of his answer. Is that correct?
Do I have to advise one of the consequences of their?
Well, you were interrogating him.
I'm sorry?
Well, I'm just asking, you did not advise him of the consequences of his answer.
No, at that point he wasn't in custody.
Okay. But you asked him a question, and the fact that he did not answer right away made you believe that he was committing a crime.
It wasn't just that, ma'am. It was when we made contact with him looking in multiple directions, looking for a plan to escape. His inflection in his voice, his hesitation, again, with the eye contact, looking for where he's gonna run. We've had plenty of different runs with Mr. Mcfaden where he has run from us, so it's happened in the past.
Okay, so you admit that you already knew him.
I didn't know him at that time, but I'm saying that people often run from us, and that is a characteristic of someone that's about to run. The pre-flight indicator is a better description of it.
Well, you just testified though that you had plenty of interaction with him, previous interactions when he's run.
I have, but I didn't recognize his face at that time, but the characteristic that he demonstrated was an example of a pre-flight indicator that often happens. People run from us in our team almost every other night.
Okay.
So it's very easy to pick
So
up
at the
on
time
before.
that you were having this interaction, you didn't immediately recognize him?
No, ma'am. No, I did
So
not.
that wasn't a consideration at the time of how
Correct.
you performed your investigation?
Correct.
Okay, but after the fact, you realized you've had contact with him?
Absolutely.
Okay, thank you.
And actually, you did ask him, or Schaefer in your presence, ask him if he knows, he asked him that you asked him the question, you look familiar.
That was after the fact, I believe, correct?
I wasn't there.
Yeah, I don't recall. I'd have to look at my body on camera to see if he was already painted handcuffs at that time. And when I said you look familiar, or if he hadn't.
Okay, so you testified that one of the characteristics that he was exhibiting was nervousness, correct? He was
Correct.
looking around, and you also testified that it's a hot spot. It's a dangerous spot.
For guns, it's an easy area where we can observe people from a long distance away and observe people openly carrying firearms.
And it's possible that when he was looking nervous, looking around, it's possible that he was trying to observe what was in his surroundings, correct?
It's very possible.
So if you are someone, it doesn't really mean that he's looking nervous because he committed a crime.
When I was talking to him, when I sensed his nervous behavior, it was after Trooper Schaefer had already made contact with him.
And you're not surprised that Black men are nervous when they are around the police.
I'm not going to answer questions based on race. I treat everybody the same. I've never had an instance with somebody based on their race or based on their gender, where I've judged the situation specifically off that. So I've lived near the city of Lansing my entire life, and I've grown up in this community. So.
Well, the question was, you're not surprised that a Black man would be nervous
Yes, sir.
interacting with a police officer? You can answer if you're surprised or not, or if you don't know.
I don't know how to answer that question.
You don't know.
I think everybody has the right, has their own.
We're not talking about everybody. This is a very
Okay.
specific question. And you can, you have three options in your answer. Yes, you're surprised. No, I'm not surprised, or I don't know.
I don't know.
Okay,
I have no further questions for that.
redirect.
Just briefly. Trooper Black, did you, in your interactions with Mr. Mcfaden, did you ever learn if Mr. Mcfaden had a concealed pistol license?
I learned he did not. Yes, sir.
Oh, and how did you learn that?
I conducted a lien and SOS check to verify that. And then after he's a convicted felon, obviously he got eligible to.
Okay. No other questions, Your Honor?
May this witness be excused?
Yes, Your Honor.
Okay, and Trooper Black, there is a sequestration order, so you're not allowed to talk about any portions of your testimony with any other witness, okay?
Yes, sir.
Thank you. Any additional witnesses?
No other witnesses, Your Honor.
Is the defense calling witnesses today?
No, you're not.
You can proceed to argument.
Thank you, Your Honor. The people would ask that this be bound over to the circuit court as charged in the complaint. We heard testimony today from Trooper Luke Schaefer, who testified that he was conducting surveillance, and I believe he said Royal Liquor, which was located at 3325 South MLK Boulevard in the city of Lansing, Ingham County. While he was conducting surveillance there, he observed a subject who he was holding a heavy object in a secondary hoodie pocket. And so he maintained observation of that individual. While he was observing that individual displayed characteristics which he described in his training and his experience as characteristics of someone holding a firearm. He then proceeded to continue to observe that individual walk into the store, then leave the store, still with a heavy object in that hoodie pocket. He then testified that he had undercover VCI officers do a drive-by. And when the undercover officers did that drive-by, the suspect he was observing continued to display the behavior that he testified in his training and experience was consistent with someone carrying a firearm. Trooper Schaefer then testified he, at that point, made contact with the individual in a parking lot, and he asked the individual what was going. He started to question the individual, though the individual had not been detained at this point. He said the individual began talking quickly, gesturing with his hands, displaying nervous behavior, which again, in his training and experience, is again consistent with someone concealing a firearm. He then testified that Trooper Black and arrived on scene and began to question the suspect, as the suspect was not very cooperative with Trooper Schaefer. We then, her testimony from Trooper Black, who testified that when he arrived on scene after being in radio communication with Trooper Schaefer, that he observed a noticeable L shape of a handgun in the front hoodie pocket. And when he confronted the individual who was identified here today by both troopers as the defendant, Ralph Mcfaden, about having a handgun on him, that Mr. Mcfaden admitted that he had a handgun on him, which was concealed in that hoodie pocket and was recovered by Trooper Black. At that point, Trooper Black testified that they arrested Mr. Mcfaden, Mirandized him, and that during the interview, after he was Mirandized, that Mr. Mcfaden admitted to having the firearm, admitted to, told officers where he had found the firearm, and also admitted that he was a convicted felon and knew he was not supposed to possess a firearm. By that, Your Honor, I believe the people have met their burden by probable cause evidence that Mr. Mcfaden was, at the time he was stopped, and knowingly carried a pistol, which was concealed in his front hoodie pocket, and that he did not have a CPL, as testified to by Trooper Black, who ran a lien and SOS check on him. I believe the people have also met by probable cause evidence that Mr. Mcfaden was a felon possessing a firearm for a specified felony, that being the underlying crime of CCW, which was displayed in People's Exhibit 1 of the certified record of conviction. And I believe the people have also met by probable cause evidence count 3, felony firearm, that Mr. Mcfaden did carry a firearm in the commission of the offense of felon in possession. And so with that, people would move that this be bound over to the circuit court as charged in the complaint.
Ms. Wandy?
Thank you, Your Honor. You know, the main problem that we have with this case is that my client was walking, he went to the store, to 2 stores, he was walking, did not commit any crime, he looked nervous, but the police officer said that he looked nervous, but he also admitted that it's possible that he was looking nervous for other reasons. What we have here is just the fact that the police officer tried to contact people, arrest people without any reasonable suspicion that they have committed a crime. This is still in America where you cannot just walk in the street and not having to be harassed by the police. He did not commit a crime. He was not looking violent. He did not have a dangerous position. He was not looking violent and dangerous. They saw him and they said, well, you know, we're going to stop him and decide whether or not he has a gun. But he was going to this school, or he was walking in a legal way. He did not commit any crime. The police was asking him, and we believe that there was no circumstances where they could have arrested him. The police officer did not observe him commit a crime. They did not observe him commit a misdemeanor. And we do believe that there was no reasonable suspicion to stop him. And we believe that the gun that they found on him should be suppressed and that the case should not be found over.
Thank you. Today was the date set for preliminary examination. Mr. Mcfaden, for your information, the purpose of the preliminary examination is to require the prosecutor to establish whether or not they have sufficient evidence to support the burden of probable cause. So they have to establish whether or not they have enough evidence of probable cause that a crime was committed and probable cause to charge you with the crime. In this case, you've been charged with count 1, weapons carrying concealed, count 2, weapons firearm possession by felon, and count 3, weapons felony firearm. So this is not a trial. The burden is not on the prosecutor to meet the standard of beyond a reasonable doubt. That's a much, much, much larger burden than what they're facing here today. Today is just more than mere suspicion that a crime was committed. So it's a very low burden. And it's based on the articulated facts and evidence presented at today's proceeding, and the court was the sole determiner of credibility. And the court also weighs the likelihood of the prosecutor's success at the time of trial. So we had testimony today from First Trooper Schaefer. He testified that on or about November 7th, 2023, that he was doing surveillance in the area of 33325 South Martin Luther King Boulevard in the city of Lansing, Ingham County, state of Michigan, which makes venue appropriate before this court. He stated that address is also known as the Royal Liquor. He described that to be a hotspot location. I think hotspot probably came up multiple times today, and indicating that's an area where they commonly find activity involving guns, drugs, and or stolen vehicles. I can also say at this point in my own experience, that is a common spot where they find guns, drugs, and stolen vehicles. And so it's common for an officer to be posted in that area. The officer testified that he identified, or he saw an individual that he identified in the court as the defendant in this matter, Mr. Ralph Mcfaden, that he was approaching the door, I believe he said from the south side, south entrance to the store, and that the defendant appeared to have one hand, and specifically left hand in the top hoodie pocket, right hand in the secondary hoodie pocket, which caused some concern for that officer. The officer also testified that he observed Mr. Mcfaden to walk towards the south end entrance and constantly looking around, which he believed to be an indicator that the defendant may have been carrying a firearm, and that he also noticed that there was something in one portion of the pocket. I believe he said it was the secondary pocket. Nonetheless, he said that he found this behavior to be odd, that there would be one hand in a pocket that he did not believe it had anything in there. He called for a undercover trooper, that being Trooper Cody Black, to observe or assist in observing the defendant as the defendant left the store. The trooper claimed that he was still watching the defendant as the undercover trooper observed the defendant walking. The Trooper Schaefer testified that he did observe the defendant make some adjustment to whatever was in his pocket as he was walking away from the store, and that he continued to look over his shoulder in a way that he described as a security check. He made contact, he said, with the defendant. The defendant became nervous, was talking with his hands, and stated that he was coming from the store. On cross-examination, Trooper Schaefer was questioned about whether or not it was reasonable or possible that the defendant may have purchased some items while he was coming from the store. The officer indicated, yes, it's reasonable, but that he was looking at things more or less from a totality of circumstances. And we had Trooper Cody Black testify that he made contact with the defendant on the same date, time, and question at the area at or near Southland and Washington upon being alerted by Trooper Schaefer, and that both of these officers are part of the Secured Cities Partnership. He described the defendant to be exhibiting characteristics of carrying a firearm, and he described that what he said, seeing an imprint of a firearm, and that the defendant appeared nervous, that he asked the defendant or the subject before the court if he had a CPL, that Mr. Mcfaden did not respond, but then when indicated that he knew that the defendant had a gun on him, that Mr. Mcfaden admitted to having a firearm, indicated that he had found the firearm on the ground on his way to the store. And then later, after being Mirandized, providing information that he was carrying the firearm for his own purpose, but that he knew that he was not eligible to carry a firearm because he was a felon. The question before the court is whether or not there's probable cause sufficient to support count 1 of weapons carrying concealed. At trial, they would need to prove beyond a reasonable doubt that the defendant first knowingly carried a pistol, and that it does not matter why the defendant was carrying the pistol, but to be guilty of this crime of carrying a concealed weapon, they would need to prove beyond a reasonable doubt that the defendant must have known that he was carrying a pistol. Second, that the pistol was concealed on or about the person of the defendant. Complete invisibility is not required. A pistol is concealed if it cannot be easily seen by those who come into ordinary contact with the defendant. The concern or the issues that the court does foresee in this case, I think are highlighted, interestingly enough, both troopers, when questioned about one of the characteristics that they highlighted, which is the defendant appeared nervous. And defense counsel asked both officers separately if they were surprised that a Black man was nervous or experienced nervousness when interacting with an officer. And it appeared to the court that both of those troopers attempted to evade answering that question. I can't surmise why they would evade that question. We live in America. We're not oblivious to the things that have gone on, not just in this current date and time in this country, but for history of this country, and things that sometimes, more often than it should, in situations and circumstances that involve law enforcement and interactions with people of African American descent. And so to have a trooper under oath try to evade that question reflects to me that either there is a lack of credibility in their response, or it could be that they're oblivious to the issues that have plagued this country for centuries, or it could be that they're naive or just irresponsible. I don't know which one it is, but neither one of them were willing to answer that question and what the court believes to be honest and responsibly. You can't be an officer, I don't believe, or work in any law enforcement capacity, or even be a upstanding and responsible citizen in the United States of America and not recognize that a Black man would experience some nervousness when interacting with law enforcement, whether they are committing an act against the law or not. So that was irresponsible, and I have great disdain for the way that they attempted to answer those questions. However, as it relates to why we're before the court, there's sufficient probable cause because based on the totality of what they represented, it wasn't just nervousness, it was retention touches, it was what they believed to be a heavy imprint and or an imprint of a firearm being seen that caused them to stop and question or investigate what they believe to be characteristics of a firearm. And it is not the officer's responsibility to advise subjects of their rights. He has an absolute right to remain silent and could have used that right and executed that right and should have known, based on the fact that he's clearly been before the court before in Exhibit 1, that he has the right to remain silent. But if in fact, based on what they said, he willingly volunteered such information that he had a firearm, then at that point, they now have more than what they need to do a search. I believe that there's more than sufficient probable cause as to count 1, weapons carrying concealed. And based on the information provided in People's Exhibit 1, there's enough evidence to support count 2 being weapons felon, a possession by felon, and that the defendant was ineligible to carry a firearm because he had been convicted of a specified felony and had not yet regained eligibility. That not only based on or probable cause based on this exhibit, but based on the alleged testimony or admission that was provided from the officers that Mr. Mcfaden informed them that he knew he was not eligible to carry a firearm. Count 3, weapons, felony, firearm. There's sufficient evidence based on the testimony that the defendant was carrying a firearm, which was located by officers during their investigation. So counts 1, 2, and 3 will be bound over to the circuit court for further prosecution. Your bind over date will be December 20th at a time to be determined by the circuit court. That is not a date, Mr. Mcfaden, that you need to appear in circuit court. That's the date that they get the file from the district court, okay?
So I just wait till they call or email?
They will, after that date, they will set your next court date. It'll be a pre-trial and your attorney will be made aware of that date, okay? You stay in contact with her, and I believe you may still have a matter pending before me. Is that correct? Do you have another matter? I think so. You have a misdemeanor.
Oh,
Okay, so don't get that confused and then not show up on that matter, okay?
Yes.
Do you have
Wait,
any
today?
questions? It's not today.
Oh, okay.
No, we don't do
Today.
misdemeanors today typically.
Okay.
Okay, but you can find out, we can tell you what your next court date now is if you want to know for your misdemeanor.
Yes.
January 16th, okay?
Okay.
You stay in contact with Mr. Raleigh, okay? Do you have any questions?
No, Your Honor.
Okay, your bond in this matter, 10,000 cash surety, will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
Just one question. What is the bind over date?
Bind over is December 20th.
Thank you.
No problem.
No further questions, Your Honor.
Thank you. You're all set.
Thank you.
Here's your exhibit, Mr. Bartlett. And then,
Your
uh,
Honor,
yes, sir,
just real quick, was Mr. Shakir Rogers Jameson bench warranted
he
already?
was.
Okay.
Let's see, we have Hodges and we are completing that, is, oh, just
I
bind over
believe that'll
argument?
just be a motion for bind over, Your Honor. I don't believe people's witnesses appeared yet.
Okay, and then Joseph, are we running that?
I believe so, Your Honor.
Would you like us to bring him up now? Mr. Freeman,
Good morning, Your Honor. Pardon me.
would you like us to have him brought up now, or did you want to have lunch first? It's your,
Well, I have
your
another
call.
exam in front of Judge Buchanan. at
Well, then we'll bring him
1:30,
up
so
now.
yeah,
We'll bring him up now.
Thank you.
Thank you. And then we'll do bind over arguments on Hodges after that. You wanted that one turned off because you couldn't hear Mr. Freeman.
Oh, you want that? That's all I hear and I hear me to say.
That one? I want that one on though.
Okay. Thank you.
You can be seated. Okay. Okay, on the record, in the matter of the people of the state of Michigan versus Gene Joseph, file number 23-03189, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Stephen A. Freeman, Your Honor, Assistant Public Defender, on behalf of Mr. Joseph.
Okay, today was the date and time set for a preliminary examination, and we are ready to proceed. Do we have any preliminary matters before we call witnesses?
Two, Your Honor. One is that I would present to the court what has been marked as People's Proposed Exhibit 3, and I would move for admission under the court rule for People's Proposed Exhibit 3, as it is a certified record of conviction from the 30th Judicial Circuit for Mr. Gene Joseph Jr. I have showed it to Mr. Freeman. Permission to approach, Your Honor.
Any objection?
No objection, Your Honor.
Thank you. People's 3 is admitted. Any other matters?
Then briefly, Your Honor, because I believe the defense will ask for it, a sequestration order. Your Honor.
Sequestration is ordered. How many witnesses?
I believe I will have 4 witnesses, Your Honor.
4 witnesses. Are they?
There are 3 here in the courtroom, Your Honor, and then 1 is in the back room.
Okay, sequestration is granted. You can remove your witnesses from the courtroom. And with the sequestration order, that means you're not allowed to discuss any portions of your testimony with any other witnesses, okay? Okay, and then you can, any preliminary matters for you?
Thank you, Your Honor. No.
I heard it echo. Did you hear that? Okay.
I believe that was my computer.
Oh, okay,
Your Honor,
sounds
I've
good.
muted it since.
Very good. Okay, you can call your first witness.
Thank you, Your Honor. People would call Mr. David Bullion.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, sir.
Thank you. You can have a seat. There's a microphone that's in front of you. I apologize that those are tight quarters. Please believe you're not the first person just this week to have this issue. It's a common issue, but our future accommodations will be better. Nonetheless, there's a microphone that's in front of you, and the lady behind you is my court reporter. She needs to take down everything being stated here today. We have a fan going, and we have this plastic right here to protect us from viruses and such. If you can keep your voice up loud and clear, and then make sure your responses are verbal, no head nods or shakes, okay?
Yes, Your Honor.
If there's an objection by either of the attorneys, you will stop speaking immediately. I'll make a ruling on the objection, and I'll tell you if you can give the answer to that question or not. Please state your first and last name, spell both.
David Bullion, David Bullion, or Ion, I'm sorry.
Say it again.
Bullion.
Okay, thank you. You can proceed.
Thank you, Your Honor. Good afternoon, Mr. Bullion. Mr. Bullion, how are you employed?
The shift manager at Quality Dairy.
Okay, and what location Quality Dairy do you work in?
10 in Kavanaugh, number 9.
Okay, and do you know the exact address of that?
Yeah, 917 East Kavanaugh.
Okay, and is that location in the city of Lansing?
Sure is.
In Ingham County?
Yep.
Okay, and were you working, I guess it would be the night of October 20th into the morning of October 21st?
Sure was.
Okay, and did something happen on that date?
Yes, there was.
Okay, and when did, or I should say, what happened?
Well, I was taking a break outside the front door. I had a gentleman come around the corner, point a gun at me, told me to get back inside, give him all the money, no trackers.
So let me stop you right there. So this gentleman approaches you with the gun. Do you recall what time of day this was?
I guess 1:40 a.m.
Okay, so this would have been the morning of October 21st, correct? Okay. So gentleman comes around the corner with a gun. I believe you said it, but just to clarify, what happened at that point?
He put a gun to the back of my head, told me to get back inside. We walked inside the store. I emptied out both the registers. This whole time he's telling me not to give him a tracker, open up the safes. So I gave him what we got behind the counter, both the tills. He walked out the store saying something about us being broke and left.
Okay, and were you working alone that night?
No.
Okay. Who was working with you?
I had another shift manager, Kyle.
Do you recall Kyle's last name?
Cisco.
Okay. And being as you're the shift manager, I'm just wondering, are there security cameras in the quality dairy where you work?
Yes.
Okay, and if you know, how does that system work?
It's just like any other, like if you've got cameras at your house, you set it up to a computer, you get to record it. If you've got an SSD, you can save the footage and replay it back.
And where are those recordings stored?
Just in the back room of our store.
Okay. And those recordings, are they made through the regular course of business?
Yeah.
Okay. So, Mr. Bullion, I am going to show you a short clip of what has been marked as People's Proposed Exhibit 1. Permission to approach here?
Yes.
I can't hear you.
Mr. Bullion, do you recognize that footage?
Yes, I do.
And what is that footage of?
It's footage of our security camera just above our tills in the front door entrance.
Okay, and is that a fair and accurate representation of what happened that night?
Sure is.
Okay, at this time, Your Honor, people would move for admission of People's Proposed Exhibit 1.
Any objections to People's One?
Objection.
People's One is admitted.
At this time, Your Honor, I would ask permission to play People's One for the court.
Yes.
And I'm going to rewind it to the start of the video, Your Honor. So
Is there sound on this?
there is, Your Honor. However, I believe it's ambient sound from.
Okay, sounds good.
As this was recorded, so I don't believe there's actual sound on the security footage itself, Your Honor.
Thank you.
Yeah, that's good. You can play it.
You are turn to your left and walk straight. What I'm seeing is directly in the front car. Keep moving forward. The person's looking left. There you go. Keep moving forward. Keep moving forward. We'll be at here 11 o'clock at the break of the wood line, just at the base of the power line pole. Okay, it's here 11 o'clock. Should be about 30 feet from the east of the front gate at the base of the power pole. Should be on top there right now. The storm's right. Alright, hang tight, let me get higher. So hey. No, again.
So, Mr. Bullion, what did you do, if anything, after the robber left the store?
We got a hold of all of our supervisors and higher ups, told them what just happened, let all of our other stores know what happened. Closed immediately.
And did you ever contact the police on that night?
Yes, of course.
Oh, and did you show the police that security footage?
Yes.
Now, the individual who robbed your store, did you see his face?
Excuse me?
Oh, no, I'm sorry. He was wearing a mask.
Okay. No further questions, you know?
Cross-examination.
I think just one, Mr. Bulling, do I understand your testimony that you're not able to identify anyone as the individual who robbed the store?
And the night of, someone was wearing a mask, yes.
I can't hear you.
The night of the robbery, the person was wearing a mask.
Right, thank you, nothing else, Judge.
Okay, any redirect?
No questions, Your Honor.
This witness can be excused?
Yes, sir.
Okay, thank you, Mr. Bullion. You can call your next witness.
Thank you. People would call Victor Cisco.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
Thank you. You can have a seat. There's a microphone that's in front of you, and the lady behind you is recording everything that's being stated here today in court. So you need to make sure your responses are loud and clear, okay?
Yes, Your Honor.
Also, make sure they're verbal. You can't do head nods, head shakes, or mm-hms and uh-huhs, okay?
Yes, Your Honor.
State your first and last name, spell both.
Victor Cisco.
Spell.
VSETORSISCO.
If there's an objection from either attorney, you will stop speaking. I'll make a ruling on the objection and then tell you if you can give that answer or not, okay?
Yes, Your Honor.
You can proceed, counsel.
Thank you, Your Honor. Good afternoon, Mr. Cisco.
Good afternoon.
Mr. Cisco, how are you employed?
Coordinator.
Okay. And what specific location do you work in?
917 East Cavanaugh.
Okay. And is that location in the city of Lansing?
Yes.
In Ingham County?
Yes.
Okay. And were you working on the morning of October 21st, 2023?
Yes.
Okay. And did something happen on that date?
We were armed. We were robbed about 2 o'clock in the morning.
Okay. So how did that incident begin?
I was in the process of doing our lotto count, getting ready to close up, and then next thing I looked up is the perpetrator coming in with a concealed weapon.
Okay.
Pressing
And
a lot of money.
when you say a concealed weapon, can you describe what you mean by that?
Big, long, like,
Okay.
by gun.
Okay. Was this when you say big long gun, was this a handgun, rifle? How was it?
Almost like a rifle.
Okay. And what happened when he entered the store?
Demanded for the money, open up the till, hand him all the money.
Okay. And did you personally hand the suspect money?
Yes, I did.
Okay. And what happened after you did that?
After that, we locked up and then we called for the cops and everybody in the security.
And to the best of your recollection, did you see the face of the individual who?
He had a mask on at the time.
Okay. Do you remember?
The only thing I saw was his eyes.
Okay. Do you remember what any other clothing that the suspect was wearing?
Like a jacket, sweater.
Okay. No other questions at this time, John?
Cross-examination.
Thank you, Your Honor. Mr. Cisco, the money that you gave this person, was that money that belonged to Quality Dairy?
Yep, came right out of God too.
Did you give the individual any of your money?
No, I did not.
anything that belonged to you. Anything the robber left with belonged to the store. Is that true?
In fact,
Anything that the robber did leave with had belonged to the store.
not to my knowledge, no.
In other words, anything that the robber took away from the store was property, cash that belonged to the store.
Yeah. All right, yep, just the cash.
Okay, thank you. Nothing else, Judge.
Redirect.
Other questions, Your Honor?
May this witness be excused?
Yes, Your Honor.
Okay, thank you, Mr. Cisco. You can be excused. Call your next witness.
Thank you, Your Honor. The people would call Mr. Daniel Blackburn.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
Thank you. You can have a seat. Okay, the lady behind you has to take down everything being stated in the courtroom today. There's a microphone that's right in front of you, so make sure all of your responses are loud and clear, that you don't just rely on head nods and shakes. You have to say yes or no, and we can't do uhs and ahs either because we can't understand that in the record, okay?
All right.
If there's an objection by one of the attorneys, you will stop speaking. I'll make a ruling on the objection, and then I'll advise you if you can give that answer or not, okay?
All right.
Spell your first and last name for me.
Daniel Blackburn.
Okay, you can proceed, counsel.
Thank you, Your Honor. Good afternoon, Mr. Blackburn. Mr. Blackburn, how are you employed?
With Quality Dairy.
Okay. And what specific location do you work at?
The 6099 South MLK.
Okay, and is that location in the city of Lansing?
Yes.
In Ingham County?
Yes.
All right, and were you working on the morning of October 21st, 2023?
Yes.
Okay, and did something happen on that date?
We were robbed.
Okay, can you explain how that incident began?
I was standing behind the counter, the door was forced open, and a gentleman came in pointing a gun at me, yelling at me to give him money and open safes.
Okay, and what were you thinking at the time when the individual came in with the firearm?
That he's got a gun, and I should give him what's in the registers.
And so can you describe the gun this individual had?
It's dark in color, extended clip. That's about all I know.
Was it a handgun?
Right, a handgun.
Okay.
Yes.
And so what did you do at that time?
I opened my register, gave him all the money that was in it, then proceeded to give him the money out of my coworker's register.
Okay. And were you working alone that night?
I was not alone, but I was the only one on the floor. My supervisor was in the office doing paperwork, and the coworker was in the room.
Okay. And Mr. Blackburn, to the best of your knowledge, are there security cameras at the Quality Dairy where you work?
Yes.
Okay, and do you know how those security cameras record footage?
They record it and send it to the office. I'm not sure.
Okay, and are those recordings stored on site?
Yes.
Okay, and are those security recordings made in the regular course of business?
Yes.
And to your knowledge, were those cameras running, were the security cameras running the morning of October
Yes.
21st? Okay. At this time, Mr. Blackburn, I'm going to show you what's been marked as People's Proposed Exhibit 2. Permission to approach, Your Honor?
Yes.
Just a short clip. Mr. Blackburn, do you recognize that footage?
Yes.
And how do you recognize it?
And that's the night we got robbed.
Okay, and is that a fair and accurate representation of what happened that night?
Yes.
At this time, Your Honor, people would seek admission of People's Proposed Exhibit 2.
Any objection?
No, Your Honor, thank you.
People's 2 is admitted.
At this time, Your Honor, I would seek to play People's Proposed Exhibit 2 for the court.
You can.
For the record, I am beginning People's Exhibit 2 at 2 minutes and 15 seconds of the recording, Your Honor.
Let's go sweatshirt. He was telling him to open the safe because I could hear. And that's why he said, I can't open the safe. When you do your work, you'll be able to get a picture of him.
Oh, yeah. Oh, yeah, and I'll have the video, total video.
Any good angles on him?
Couple.
That's good.
Are you okay?
Yeah.
I mean, I know you shook
Oh.
up. Yeah, I know you shook up, but I want to make sure everyone,
Not hurt or nothing.
Right, that's, I mean,
yeah.
I know
As far as timing, it couldn't have been better because we just gotten done with the end of the day start over, so there's as little money
So yeah,
in
there
the
was
drawer as
only,
possible.
and then my register hasn't been open, so that's why he couldn't open the middle one.
I was thinking maybe I should have tried to log in.
And again, just for the record, Your Honor, people were admitting that for the video, not the noise in the background from the recording, Your Honor. So, Mr. Blackburn, after the robber left, what happened?
After the robber left, I went into the back office to converse with my supervisor. She was already on the phone with the police.
All right, and how long after this incident did police arrive?
Within minutes.
Okay, and to the best of your knowledge, did the police review that security footage?
Yes.
No further questions, Your Honor.
Cross-examine.
Thank you, Your Honor. I have no questions for the witness.
Witness be excused.
Yes, Your Honor.
Thank you, Mr. Blackburn. You may be excused, or Blackburn, you may be excused.
Okay.
You can call your next witness.
Thank you, Your Honor. People would call Officer Damon Coleman.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Thank you. You can have a seat, officer. State your first and last name and spell both.
Damon Pulver, DAMONPULVER.
Okay, you can proceed, counsel.
Thank you, Your Honor. Good afternoon, Officer Pulver.
Hello.
Officer Pulver, how are you employed?
I'm employed with the Lansing Police Department.
And how long have you been with the Lansing Police Department?
I've been a police officer for around 3.5 years.
Okay, and what's your current duties with the Lansing Police Department?
I am currently assigned as a police officer to the Road Patrol Division.
Okay, and were you working in that capacity on the morning of October 21st, 2023?
I was.
And how were you dressed that day?
I was dressed in full departmental uniform.
Okay. And at some point in that morning, did your duties take you to 917 East Kavanaugh?
It did.
And what's at that location?
That is a Quality Dairy location.
Okay, and is that location in the city of Lansing?
It is.
In Ingham County?
It is.
And why were you dispatched to that location?
I was dispatched to that location for an armed robbery.
Okay, and when you arrived at that location, how did you proceed?
When I arrived at the location, I spoke with one of the clerks that was robbed and obtained their statement.
Okay, and what did you do after that?
I helped take the police report and reviewed some video camera footage from it and documented it, and then ended up leaving the store.
Okay, and when you reviewed that security footage, what did you see?
When I reviewed this security footage, it showed a male walking up to the store and holding one of the clerks outside at gunpoint, forcing them inside to the store, and then still at gunpoint robbed the two clerks of two different cash registers.
Okay, and do you remember, if you remember, do you remember how the robber was dressed at that time?
The robber was dressed with a black sweatshirt with a white stripe going down the side, light blue jeans, red shoes, and had a black face mask on, a ski mask, and then also had a bright blue sweatshirt in his hand.
Okay, and I believe you may have said this right, but after you viewed that security footage, what did you do?
I took photos of the security footage and documented it, and then ended up leaving the store after I taken photos of it.
Okay. And what did you do after you left the store?
After I left the store, I went back to my normal routine patrol, which at some point shortly after, I was about an hour or so after that, I was dispatched to another armed robbery of another QD store.
Okay, and do you recall the location of that QD store?
It was at the Quality Dairy at the corner of South Martin Luther King Jr. Boulevard and Miller.
Okay, and is that location in the city of Lansing?
It is.
In Ingham County?
It is.
Okay, and you said, why were you dispatched to that location?
I was dispatched there for an armed robbery.
Okay, and when you arrived at that location, how did you proceed?
When I arrived at that location, there were other officers that arrived in the area prior to me that located the subject that was running or fleeing from the scene. So I assisted in setting up a perimeter for a canine trap. And other officers later took the subject into custody from that.
Okay, so you were informed that a suspect was caught.
Correct.
Okay, and what did you do after you were informed the suspect was caught?
After I was informed that the subject was caught, then I went to the jail to help type up the police report. I spoke with officers on scene and compared and contrasted the photos from the 917 East Kavanaugh robbery to the robbery at King and Miller. And we confirmed that it was the same subject. And when we got to the jail, I helped interview the accused subject. So between being at this QD location, hearing the suspect was caught and arriving at the jail, was there anything else you did that night? Yes, I went to the scene of where the accused subject was located, and I helped search for a firearm and later located that firearm. Okay, and can you describe the firearm you located? I don't specifically remember the exact description. I believe it was a black handgun that was located in the front yard. Okay, and did you find anything else at that time? I also located the clothing that the accused subject was wearing. But he apparently had tossed while he was running from the police. Okay. So at that point you stated, and do you remember what specific clothing that was? If I remember correctly, I believe it was the black sweatshirt and the light blue sweatshirt. I have to look at my report to verify exactly what it was. That wasn't it. Yeah, if you saw your report, would that refresh your recollection? Okay. Permission to approach your own? Yes. Okay. Permission to approach? Yes. Officer, did that refresh your recollection? It did. All right, so what other evidence did you find in it? So I located the firearm in the front yard of 5915 Hughes. And then south of that location, I located the black sweatshirt and the light blue sweatshirt.
Okay. And so then I believe you stated you went to the Lansing, would it be the Lansing City Jail with other officers?
Yes.
Okay. And did you participate in an interview of the suspect?
I did.
Okay, and prior to participating to that interview, did you identify the suspect?
I wasn't the exact person that identified him, but I was part of the process and.
Do you remember the name of that suspect?
Yes.
And what was it?
Gene Joseph Jr.
Okay, and do you see Mr. Joseph anywhere here in the courtroom today?
I do.
And can you please identify where he's sitting in an article of clothing he's wearing?
It is the subject sitting right over here with the blue jumpsuit on and the white wristband.
At this time, people would ask that the record reflect the witness has identified the defendant.
Any objections to identification?
No objection, Your Honor.
Identification is noted.
So I believe, I may have asked already, but Officer Pulver, did you participate in an interview of Mr. Joseph?
I did.
Okay, and prior to this interview, was he read his rights?
He was.
And did he waive those rights?
He did.
And what did you learn from Mr. Joseph during this interview?
During this interview with Mr. Joseph, he admitted that he was the accused in the armed robbery at the King and Miller armed robbery, and then denied that he was the armed robber for the QD robbery at 917 East Kavanaugh. I ended up showing Mr. Joseph a photo of the accused subject in both of those cases from surveillance footage, and he later admitted that he was the accused subject in both of those armed robberies.
Did you learn anything else from Mr. Joseph at this time?
I tried asking him a lot of different questions about how he got there and his mode of transportation in between each. He was very vague about his answers and didn't seem to want to get into all the specifics about it, but just continued to say that we caught him. And that was the accused.
No further questions at this time, Your Honor.
Cross-examination.
Yes, Your Honor. Thank you. Officer Pulver, is that right?
Yes, sir.
You said you've been an officer for 3+ years?
Yes, sir.
How old are you?
I am 24 years old.
Greatest job you ever had, isn't it?
It's a great one.
And they pay you to do it.
And they pay me to do it.
Did you recover any ammunition?
I don't recall if there's any ammunition.
If your report did not indicate recovery of any ammunition, would you think that that was probably accurate?
I don't know.
Okay. That's all I have. Thank you very much.
Redirect.
Nothing, Your Honor.
May this witness be excused?
Yes, Your Honor.
Thank you, officer. You may be excused.
Thanks, sir.
Please call the next witness.
People have no further witnesses, Your Honor. People will rest at this time.
Defense calling any witnesses?
No proofs from the defense, Your Honor, no.
Argument.
Yes, thank you, Your Honor. The people would move that this be bound over to the circuit court as charged in the complaint. We heard testimony from 4 witnesses here today, Mr. David Bullion, and Mr. Victor Sisko, and Mr. Daniel Blackburn, and Officer Damon Pulver. In the testimony of both Mr. Bullion and Mr. Sisko, they both testified that they were working the morning of October 21st, 2023, when an individual armed with a handgun entered the store and proceeded to rob the store at gunpoint, with both of them giving over money to the robber. We also viewed that robbery, which Mr. Bullion testified to was accurate, in People's Exhibit 1. We then heard testimony from Mr. Daniel Blackburn, who testified that, we also heard testimony from Mr. Sisko and Mr. Bullion that they both were working at the QD, the Quality Dairy located at 917 East Kavanaugh, which is in the city of Lansing, Indian County. We also heard testimony from Mr. Daniel Blackburn, who testified that on the morning of October 21st, 2023, he was working at the Quality Dairy at 6099 South King Boulevard when an individual armed with a handgun came in and robbed the store. We also saw video footage, which was testified to by Mr. Blackburn as being accurate, of that robbery. And we can see from the video footage that is the individual in both is dressed the exact same. We then heard from Officer Damon Pulver, who testified that he was dispatched to both locations for the robbery, that he viewed the security footage from the first armed robbery, and that after he was notified by other law enforcement that a suspect had been caught, he went to the area where the suspect was caught and recovered a black handgun with an extended magazine, a black sweatshirt with a white stripe down the arm, and a light blue sweatshirt, which we can see in the videos presented in Peoples 1 and 2. He then testified that he went back to Lansing Police Department headquarters to the jail and participated in an interview of the suspect, who he identified here today as Mr. Gene Joseph Jr. And during that interview, after Mr. Joseph was read his rights and waived those rights, Mr. Joseph admitted to robbing the Quality Dairy at 6099 South King Boulevard, but initially denied the robbery at 917 East Kavanaugh. However, after being showed pictures from the stills from the security cameras of both stores, he admitted that both pictures were him. With that, again, people would ask that this be bound over as charged in the complaint as to count 1, robbery armed, that the defendant, Mr. Gene Joseph, used force, i.e. pointing a handgun at the clerks there to commit a larceny in which he would take the property of Quality Dairy, that for counts 1 and 2, Your Honor, that the complainants, both Mr. David Bullion and Mr. Victor Cisco, were present while the defendant was in the course of committing that larceny, and that while in the course of committing that larceny, Mr. Joseph possessed a weapon designed to be dangerous and capable of death or serious injury, i.e. a handgun, and that the defendant inflicted, people would also move that this be bound over on count 3 under the same facts, Your Honor, for the robbery at 6099 South Martin Luther King Boulevard, where an individual robbed, who was and admitted with Mr. Gene Joseph, did rob the Quality Dairy with a firearm while Mr. David Blackburn was there present. People would move that it be bound over on count 4, possession by a felon, based on the fact that Mr. Gene Joseph admitted that that was him who committed both robberies, and he was armed with a handgun at the time. And based on People's Exhibit 3, the certified record of conviction, Mr. Gene Joseph is a felon convicted of domestic violence, 3rd in the 30th Circuit Court. And then the people would move that this be bound over on counts 5, 6, 7, and 8, as Mr. Gene Joseph did possess a firearm in the commission of all 3 armed robberies and the felon in possession, Your Honor. And so, as I stated earlier, people would move that this be bound over to the circuit court as charged in the complaint.
Your Honor, on behalf of my client, who insisted on going forward with this preliminary examination hearing, I believe I'm obliged to object to the people's motion for bind over. However, I do so without further comment. Thank you.
Okay, today was the date and time set for preliminary examination. Mr. Joseph, you have the right to a preliminary examination. You have the right to require the prosecution to establish here at that examination whether or not they have sufficient probable cause as to a crime being committed and sufficient probable cause to charge you with those crimes. And that's their burden to meet. They need to provide evidence that's more than mere suspicion that a crime was committed. And this is not a trial. They don't need to prove each element beyond a reasonable doubt. We had testimony today, first from a David Bullion, who testified that he was is the shift manager at a Quality Dairy located at the corner. He testified Pennsylvania and Kavanaugh, I believe, during the argument, or as it's charged, it's at or near 917 Kavanaugh, which is in the city of Lansing, Ingham County, state of Michigan. He testified that he was outside on a break at approximately 1:40 in the morning when a subject approached him with a gun and told him to get back inside, told him not to give him a tracker and to give him all the money. And he stated that the witness stated that he did give the subject the money that was in the registers, and that there was a comment made, something to the effect of them being broke. There was another shift manager, Mr. Bouillon said, that was working at that time. We then saw testimony to demonstrate what or support what David Bouillon testified to as being escorted back into the Quality Dairy at that location by someone with a firearm pointed at him and him emptying out the cash registers. There was testimony of a Victor Cisco. Let me back up. It should also be stated on the record that David Bouillon testified that he could not identify the subject or anyone in court today because that person was wearing a mask. There is testimony then from Victor Cisco, who was the other shift manager at the location of Quality Dairy at the corner of Pennsylvania and Kavanaugh, city of Lansing, Ingham County, state of Michigan. He indicated that he was inside the store doing a lotto count when the suspect entered. The suspect was wearing a mask and a jacket, and the suspect robbed them for the money in the cash register, and that the suspect only took cash, no personal items belonging to that witness. We then had testimony from a Daniel Blackrun, who is employee of Quality Dairy, and stated that on or about October 21st, 2023, at the area of 6099 South MLK, that he was working when he was robbed while standing behind the counter. He said a gentleman came in, pointed a firearm at him, and robbed the store. We saw a video from People's Proposed Exhibit 2 to support the testimony provided by the witness, Daniel Blackrun. We then had testimony from Officer Damon Pulver, who testified that on October 21st, 2023, that he was involved in an investigation involving armed robbery or two armed robberies in the Lansing area, and that the subject was identified as wearing a black sweatshirt with a white stripe, jeans, red shoes, bright blue t-shirt in his hands, that there was a K9 track. The suspect was later caught, and it was confirmed the identity, and that the individuals from both locations that were robbed was confirmed to be the same subject. Officer Pulver said he did return to the scene or the area in which the suspect was taken into custody, and he surveyed that area to locate a firearm in that area, and that he also located clothing that matched the description of the clothing that the subject in question was wearing, and that was allegedly tossed while running from police. That was the area of at or near 5915 Hughes, which is where the weapon was located. The Officer Pulver testified that he later interviewed the person he identified in the court today as Gene Joseph after him being Mirandized, and that Mr. Joseph admitted to robbing the Quality Dairy on King, but initially denied involvement in the robbery at the Kavanaugh location after being showed some surveillance. The subject or person that the officer identifies as Mr. Joseph later admitted that he was the accused in both. If this matter were to make it to a trial, the people would need to prove, for the purposes of counts 1, 2, and 3, which are all charged as armed robbery, that the defendant used force or violence against or assaulted or put in fear. In this case, it would be David Bouillon and or count 2 and Victor Cisco, or count 3, Daniel Blackrun. And second, that the defendant did so while he was in the course of committing a larceny. A larceny is the taking and movement of someone else's property or money with the intent to take it away from that person permanently. Third, that the complaining witnesses in this matter, which again were David Bouillon, Victor Cisco, and Daniel Blackrun, were present while the defendant was in the course of committing the larceny. Fourth, that in the course of committing the larceny, the defendant either possessed a weapon designed to be dangerous and capable of causing death or serious injury, or possessed any other object capable of causing death or serious injury that the defendant used as a weapon, or that the defendant possessed any other object used or fashioned in a manner to lead the person who was present to reasonably believe that it was a dangerous weapon, or that the defendant represented orally or otherwise that he was in possession of a weapon. Fifth, the people will need to prove beyond a reasonable doubt the defendant afflicted an aggravated assault or serious injury to another in the course of committing larceny. That fifth element is only applied if appropriate. And so in this situation, we had testimony, and what the officer said was an admission by this defendant, Gene Joseph, that he was the person identified in the videos that depicted robberies at the locations of 6099 South MLK and 917 Kavanaugh, or at or near that address, City of Lansing, Ingham County, State of Michigan. That video, which was shown in court, or those videos shown in court, did depict the use of a firearm, which that officer testified that he did recover at the scene on Hughes Road, where the subject was taken into custody. And based on the testimony of all the witnesses, as well as the testimony of the officer, including an admission by the person he identified as a defendant, the court is satisfied that there's sufficient probable cause as to counts 1, 2, and 3 of armed robbery. Those will be bound over to the circuit court. Count 4 is weapons, firearm possession by felon. The video did depict the person identified based on the admission through the testimony as the defendant to be in possession of a firearm. I have here in People's Exhibit 3 a certified copy of conviction from the 30th Circuit Court indicating the defendant had been convicted as of September 2017 of a specified felony, and he had not yet regained eligibility, is alleged, to carry a firearm. So count 4 of weapons, firearms possession by felon will be bound over. Count 5, 6, 7, and 8 are all charged as weapons felony firearm, alleging that the defendant did carry or have in his person a firearm, that being a pistol, at the time that he committed or attempted to commit the felony of armed robbery. There are 3 counts of armed robbery. And so there is a bind over as to those 3 counts to accompany the armed robberies. And then there is another felony count of possession by felon. And there is a count 8 of weapons felony firearm that will be attached and bound over to the circuit court. So all counts 1 through 8, as well as the habitual offender court defense notice, will be sent to the circuit court for further prosecution. Your bind over date is December 20th. That will be the date that they get the file from the district court. Okay, Mr. Joseph? Okay. And so your next court date will be a pre-trial in the circuit court. You do not need to appear in the circuit court on December 20th. Do you have any questions today? Okay, the defendant would like to remain mute. Bond was set at $25,000, 10%. Is there a reason to address bond today?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
Thank you, Bond. We'll continue. Have a good one. This is your exhibit.
Yes, permission to approach her.
Thank you. can be seated. Okay, we're on the record in the matter of the people of the state of Michigan versus Jesse Hodges, file number 23-03251. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
And Jacob Riley on behalf of Mr. Hodges.
Okay, today was the date that we continued the examination for the witness, a complaining witness to appear. My understanding is that this complaining witness was present the last time, but left before her case or her name was called. What Toby White is in my breakup. Give me just a moment. Good afternoon, Mr. White. Guess he realized he was in the wrong foot when he left. Okay, and so my understanding is that witness is not here today.
That is correct, Your Honor. The witness was subpoenaed and she is not.
Okay, sounds good. You can proceed to argument if there's no other proofs.
There are no other proofs, Your Honor. Yes, the people would move that this be bound over to the circuit court as charged in count 2 of the complaint, police officer assaulting, resisting, or obstructing. We heard testimony last time we were here from Officer Rachel Logston, who said she responded to the location of
1209 Gordon.
Yes, I want to make sure that was right. Yes, 1209 Gordon for a complaint by the victim in this matter, Ms. Deborah Shattuck. She told officers that on that morning that she had a PPO and that Mr. Jesse Hodges was in the house. Officer Logsden, along with Officer Allie Cutler, responded to that address and were provided the key pad to gain entry into that house. They made entry into the house. We also viewed Officer Rachel Logsden's body camera, where we can see that she also testified that she made several loud announcements that LPD was there and for anybody inside to come out. Officer Cutler also made an announcement that she was there with a canine unit and for anyone in the house to come out. No one made their presence known, so officers proceeded to search the house room by room, not finding anyone until they opened a doorway leading upstairs. When they opened that doorway leading upstairs and made another announcement for the individual to come down, for anyone upstairs to come down, the individual identified by Officer Logsden as Jesse Hodges finally emerged from that upstairs. Officer Logsden testified that he was brushing what looked like insulation off of him, stating that she believed he was hiding up there in the insulation. He was also ordered as he was coming downstairs to raise his hand repeatedly by officers and failed to do so. With that testimony and the body cam entered, Your Honor, the people would ask that this be bound over to the circuit court as charged in count 2 of the police officer assaulting, resisting, obstructing, and that count 3 attempted interference with electronic communications follow that count along with the habitual offender notice to the circuit court, Your Honor.
Mr. Rowley, and I don't remember if I asked, but did you intend to call any witnesses?
No.
Okay, you can proceed to argument.
I do want to state for the record that I'm moving to move for dismissal of count 1, so I don't believe people have presented any evidence to support the elements of aggravated stalking. With regard to count 2, we heard from Officer Logsden at our last hearing and was confirmed on video that she and the other officer who was accompanying her entered the house. At that point, they did not see or hear Jesse Hodges or any individual inside the house. So they searched, eventually located a closed door, which appeared to lead to an upstairs attic area. Once they opened that door and made their announcement, Jesse Hodges immediately responded and followed their commands. He came down the stairs as ordered, surrendered to arrest, At no point did he physically resist or struggle. At no point did he refuse to obey their commands once he definitively heard them and saw them, their presence in the house. I don't believe there's any evidence that Mr. Hodges ever made a decision or acted in any way to resist or obstruct the officers. So I would move to dismiss count 2.
Okay, you have the video, body cam?
Yes, Your Honor, I have the video here.
Okay, if you could log back into Zoom because my notes from November 22nd reflect video. I think you paid from the 2-minute mark to 4 minutes and 22 seconds. I'd like to review that again.
This is queued up at 2 minutes. And
thank you. You can play.
Sound like a lot. Check this in that now.
What's your phone number?
It's in the case notes.
Daddy, you have to hit the.
There's no button on top.
No, she said this button.
It's gonna be 517. That's the doorbell. This is the.
4383.
Yeah.
Got it. That's it.
Lansing Police K9! Anyone inside? 1209 Gordon, you need to make yourself known. You're gonna get bit. Jesse, Lansing Police Department, if you're inside, you need to come out now. Jesse, Lansing Police Department K-9 unit with a dog. You need to come out of the house now. Lansing Police K-9. Anyone inside, 1209 Gordon, make yourself known or I'll send my dog and you will be bit. Lansing Police K-9, this is your third and final warning. Anyone inside, 1209 Gordon, make yourself known or I'll send my dog, you will be bit. Anything? Alright.
Did you say it was 4 minutes and 44 seconds?
I had 4 minutes and 22 seconds, and now there was another section where you played at the, I believe, the 9-minute mark.
Yeah. Did you wish to review that as well?
Yes, please.
Okay. This is from 9 minutes.
Shit all over the steps. Lansing Police K-9. Anyone upstairs, 1209 Gordon, make yourself known or I'll send my dog, you're gonna get bit. Stay. Come down now with your hands up. Down. Hands up. Hands up.
What the fuck? Really?
Put your hands up.
Oh my god. What are you guys fucking in for? Fuck.
Turn around, put your hands up. Hands up! Don't make any moves, you're gonna get bit.
Really? You guys, really?
Yeah, really.
What's this about?
Okay, thank you. Today was the date and the time that was set to conclude a preliminary examination that began back on November 22nd, which testimony was elicited on November 22nd, that is. We adjourn this matter for the purposes of re-subpoenaing one witness who failed to appear. The purpose of the preliminary examination for your benefit, Mr. Hodges, is so that you require the prosecutor to put forth evidence to establish whether or not they have sufficient probable cause that a crime was committed, and then probable cause sufficient to charge you with those crimes. You've been charged in this felony complaint with a count 1 of aggravated stalking, count 2 of police officer assaulting, resisting, obstructing, and then there is a count 3, which is a misdemeanor, attempted interfering with the electronic communication, and a habitual offender 4th offense notice. And so this is a standard of more than mere suspicion that a crime was committed. This is not the time for trial. At trial, the people would need to prove each element beyond a reasonable doubt. They don't need to prove that much here. It's a very low burden. Do you understand that?
Yes, ma'am.
Okay, and so we did have testimony back on November 22nd from an officer, Rachel Lawson. She testified that on or about October 25th, she reported to the address of 1209 Gordon, which is in the city of Lansing, Ingham County, state of Michigan, making venue before this court appropriate. She said she was dispatched to that address in response to a male inside the home who was in violation of a court order. A video of the officer's body cam footage was played back on that date, played again today, that shows the officers outside of the address in question, making entry using a code that the officer testified she received from the complaining witness. And that when that front door was open, you could hear and see the officers making several verbal commands for whoever's in the house to make themselves known, or otherwise the canine would be released and the subject would be bitten. The officer indicated, I think, that she was going to make her third and final warning, but watching that video, there was more than 3 actual warnings made by that officer. It is unclear to the court if from that point to the place in which the subject was later located in the home, whether or not it could be heard, what could be heard there. That I believe is a question of fact for a jury. I can't determine if someone can hear from outside or not. I would imagine that they could, but there's a chance that they could not. If someone is up in the attic with the door closed, that they may not hear or hear clearly what the orders are. The reason why I did request to have that replayed is because I wanted to then see what was stated again once entered inside the home. You see the officers looking through the property, trying to locate who's inside the home. When they get to the door, which appeared to be the door to stairs leading to a attic area or some upstairs lit space, the officer again makes verbal commands, and she testified that she made those verbal commands for whoever to come down. At that point, you see the person who they identified or officer identified in court as this defendant, Jesse Hodges, coming down and responding to their order to come down so that the dog would not go up and bite anyone. And at this point, the officers give several verbal commands to put your hands up. At no time does the person in this video appear to comply with that command. And that command was given for the officer's protection and safety. There was not only a lack of compliance based on that video, but that there was some defiance in asking or speaking back and using derogatory language back to the officers. Again, I think that whether or not the officers could be heard from the outside the house is a question of fact, but just based on that orders that were given to the subject multiple times to come down with your hands up, and that they had to repeat that multiple times, and the defendant or the person identified as defendant and the video seemingly not complying with that, the court is satisfied that count 2, police officer assaulting, resisting, or obstructing has sufficient probable cause, mainly as to the resist or oppose or endanger aspect of count 2. So that will be bound over to the circuit court. Count 1 will be dismissed for lack of evidence, and count 3, which is a misdemeanor, does not need to address probable cause. That will accompany count 2. Your bind over date is December 20th. That's the date the circuit court will get the file from the district court. And your next court date will be a pre-trial in the circuit court. Do you have any questions so far?
Okay.
Okay, a bond in this matter was set at 10,000, 10%. There was a bond motion last week to amend the bond, or on the 22nd to amend the bond, to which I denied that motion. I don't see any reason why we need to address bond at this point. Are we addressing bond?
Nothing from the people. We do have some updated information on May. Mr. Hodges had a court date in Eaton County in the case of that jurisdiction. It was granted a personal recognizance bond by that court. At this time, Mr. Hodges again would request a modification of his bond in this case. We would be requesting personal recognizance as the certainly more serious charge of the rape stalking has been dismissed.
What is he being held, or what was his bond for in Eaton County?
I believe the charge is domestic violence.
The aggravated stalking is being dismissed, is now being charged with police officer assaulting, resisting, obstructing. Based on the information I have before, or the evidence I have, I don't see that there is an immediate threat to public safety. Have you missed court in the past?
No, Your Honor. Actually, I think I have to take it now. Just like the giant suspended on years ago. Remember correctly?
You're not on probation or parole, correct?
No, ma'am.
I'll amend the bond to 10,000 personal recognizance and no contact order. That was, I think, previously in place. Will also be removed for the purposes of the fact that we're not binding over the aggravated stalking, which is the charge that attaches that complaining witness. So we'll have to amend that as well. You may or may not have, I don't know if it's the same witness in Eaton County. Okay, so it's really not germane. You're still not to have contact with that individual. You're not to be wherever that individual is based on that court order, okay?
Yes, ma'am.
Okay. My understanding is that you had some choice words about me last time you were here, sir.
Not about you.
Oh, not about me?
No. not about
Oh,
you.
okay.
Is it-
So my court officer, Mr. Bigelow, was lying?
No, if I don't remember words about you. I wouldn't say.
Oh,
words
okay,
about-
very good.
About a judge.
Okay, I'm glad to hear that. You should,
If I did, I apologize.
okay. Your bond is a 10,000 personal recognizance. You stay in contact with your attorney. Make sure he has the valid address. We have a last known address for you for Strange Highway.
It's my sister's, but I'll give you where I'm going. Whenever you're ready.
I'm ready.
Sorry, I'm lost track. 330 Iris Avenue, Lansing, 48911.
What about your phone number? Is it still the one ending in 0558?
It is, but I don't know if my phone's off. I can't remember.
Okay. Okay, well, make sure your attorney is able to get in contact with you because he'll be notified of your next court date, okay?
Okay.
Okay, do you have any questions?
No, ma'am.
Any additional matters for the record, counsel?
No, you're on.
Okay, you're all set, sir.